So I use network red. When we're ready. I know, yeah. But is that what we're gonna use?
Oh.
Network?
Yeah.
So I would just like leave it right there until you pop up. Share. Sadly, I can't reach anything without walking. I can reach it. No,
I can get it.
you don't mind?
No, I don't mind. I can get it.
Sure why this is here. If this wasn't here, we would.
I think there was a judge who wanted that there.
Well, that judge. Just go with the popular vote.
I think it was from quite some time ago.
Thank you.
Oh, you're welcome. Oh, are you going to want Russ today since we're going to be streaming still? Okay.
Since we're already started down that road.
All right. Is he still mediating? Reading that one is out there.
I was just right at the beginning when I started.
I'm so mad at yourself.
Oh. Yeah, he lost me.
Is that what it was? Yeah, he was. Then I found out after his decision. Settling that. This has been wanted.
Oh, no.
A month after.
Please rise. Superior Court is now in session. The Honorable James J. Dixon presiding.
Please be seated, thank you.
The court is.
Camera seems off for you, Judge, just based on what we're looking at.
Court is back on the record in the matter of Lisa Steele et al. Versus Olympia Early Learning Center et al. Cause number 11-2-00995-2. Good morning, everyone.
Good morning, Your Honor.
Mr. Cochran, I apologize. You said something to me, and
Oh, I was just saying that the camera looks off for you.
that's fine with me. I'm not inclined to adjust it. So, in just a matter of moments, the court is going to re-administer the oath because today's a new day. And before I do that, are there any housekeeping matters the court can take up?
One issue that I thought I'd make clear, I know that we're getting daily transcripts, and I think the court has entered an order that witnesses should be excluded from the proceedings, presumably so that they're not looking at testimony and preparing themselves based on testimony. So I want to clarify that nobody's feeding any of the, for example, Mr. McFarland, whose testimony won't be for some time, that he won't be accessing the daily transcripts to prepare for testimony.
Okay. One moment. I apologize. I need to log on to my computer on the bench. Okay, thank you. Mr. Lavison, Mr. Cochran has asked the court to,
We certainly haven't shared the Zoom link with any of our witnesses
Okay.
because the court would not let them be here at present.
thanks.
So then obviously, watching it on Zoom. I'm not sure what the difference is between us discussing with our experts as we prepare them for their direct testimony at a later date. Whether we talk to them about what was said in the courtroom or show them the transcript. It's a difference without a distinction in my mind, but whatever the court's feeling is about it, we'll abide by that.
Thanks. Mr. Cochran.
Yeah, this is the exact point. The purpose for not having a witness come into the courtroom to listen to the proceedings is so that they don't prepare like that. If you're handing them the daily transcripts, it's as if they're sitting here and listening to the testimony. So they should not be allowed to be looking at the transcripts.
The court will rule that transcripts, daily transcripts will not be provided to any of the parties' potential witnesses. That does not preclude the parties from discussing, in general terms, of course, the nature of the testimony elicited at the hearing thus far.
Thank you, Your Honor.
Thank you.
The court will ask the witness to rise, if you would please, Mr. Connolly, and I'll re-administer the oath. Do you swear or affirm the testimony you are about to provide is true and accurate to the best of your knowledge?
Yes.
Thank you. Welcome again and good morning.
Thank you. Good morning, Your Honor.
Mr. Lavison, you may continue cross-examination.
Thank you. Good morning, Mr. Connolly. How are you?
Good morning, Mr. Lavison.
Did you drive all the way back to Seattle last night?
Well, no, I live in Tacoma, so it's halfway there.
Sorry. I'm going to ask just a few more questions about what we were talking about yesterday, and then I'm going to try to move on. I think we all want to try to finish.
Hope so.
The fact that a male in his late teens was hired to work in an early learning center with children of the age of 2, 3, so forth. That doesn't mean that they're pedophiles, correct?
No, that fact alone, without all of the additional notice, would not mean that.
Okay. Do you have any problem with the learning center hiring a young male in his late teens, early 20s to do the job?
No, not without everything else that occurred.
And do you believe an employer is legally permitted to discriminate in making a hiring decision based on gender?
You're not supposed to. Now, there are times when you want a male or a female, depending on the issue, but
You understand that a background check was done before Mr. Seaver was hired?
I understand that a background check was, some type of background check was done, yes.
Okay. Do you understand that another one was done after the DUI?
I'll take your word for that. I don't recall that, but I'll take your word for that.
Okay. During opening, were you here for the opening?
No, I was not.
Okay. Mr. Cochran acknowledged, and you've acknowledged, that there was a $1 million settlement offer made by the defendants before they entered into a covenant judgment. So, settled with six plaintiffs. And the offer was included ND. But Mr. Cochran said, but of course it could not be accepted because ND was not. What are the problems with accepting a settlement offer and including somebody who's not your client?
Well, the problem is then, I mean, I'm going to separate it from this situation and answer your question. But if you're accepting a settlement offer and it doesn't include your client, then you've got to figure out allocations and so forth, and you don't have permission to accept that on behalf of that client. You don't represent them.
Okay. Do you understand? Did Mr. Cochran at any time or his firm ever represent ND?
I'm not aware that they ever did. My understanding is that they did not, but
Okay. Do you know whether Mr. Cochran signed a waiver of service?
I'm sorry?
Do you know whether Mr. Cochran ever agreed to a waiver of service on behalf of ND?
That I don't know.
You know if Mr. Cochran ever represented ND at any point in time, or if that changed at any point in time?
I don't have, my understanding is at the time the settlement offer was made, he did not represent ND. So beyond that, I can't really, I can't talk about before or after. I just know that at the time of that settlement offer, he did not.
Well, you know if Mr. Cochran ever had contact with ND?
Ever had contact with them? I don't know what the experience was with ND. I just know that at the time of the settlement offer was made, he did not represent ND.
Okay. You know but you understand that the settlement offer was made for the 6 children and families that Mr. Cochran did represent. And also for ND, who apparently at the time Mr. Cochran did not represent.
It's my understanding that on September 19th, and I sort of too late that, that they made a last ditch attempt to make a $1 million settlement offer, that the amount of coverage was still in dispute, and that they had not defended the case, and that there was already negotiations going on between counsel to accept the covenant judgments because the insurance company was not providing a defense. So that's my understanding.
It's your testimony that the insurance company did not hire Mr. Bolosina to defend the 6 plaintiffs?
I didn't say that.
Objection.
Was not providing a defense?
Objection.
Correct.
Objection is overruled. You may answer.
It's my state.
I'm sorry, there were too many people going close. I need to find each person. It takes extra time.
You have a question in mind?
So what I have is, was not providing Mr. Fowl, objection. Mr. Levison was not providing a defense. Answer correct. Mr. Fowl said objection again. The majority of the ruling, I was not able to capture that.
Ruling was overruled.
The objection is overruled. The witness may answer the question.
Okay, thank you, Hunter. The, when I say that there was no defense being provided, I'm not saying that they didn't hire an attorney. They hired an attorney, but then they handcuffed him. So what happened, and you can see this for approximately a year beforehand, the plaintiff's attorneys are trying to get mediations about coverage. They're trying to get discussions going with the insurance company. I think there's attempts to take depositions, 30B6 depositions on the coverage issue. There's a lot of negotiation going on for that year leading up to the covenant judgments. Bolasina, my recollection of the record is that there's times he wanted to get mediation. He wanted to get authority to conduct depositions. He wanted, I think at one point even asked Mr. Cochran to help him get the insurance company to pay attention and get moving. So if you ask me, did they provide a defense? My answer is no, they did not provide the defense that they're contractually bound to provide. I think they're way off providing a defense.
What evidence do you have that the insurance company ever tied the hands of Mr. Bolasina?
Well, when Mr. Bolasina is asking for depositions and they're not allowing him to take them, or when he's telling Mr. Cochran that, hey, help me get this insurance company moving, or when there's attempts at mediation and I think actually they had agreed at one point to a mediation on the coverage issue, and then they withdrew their agreement, and it's all of that is preventing him from, his job is to go out there, get experts, take depositions, particularly in a case of this magnitude, and no one was permitting that to happen.
Where in all the pages that you said you reviewed, prepare for your work as an expert witness in this case, where in those documents have you ever seen any request from Mr. Bolasina to the insurance company, or any direction from the insurance company back to Mr. Bolasina that he should hire experts or that he shouldn't take depositions?
There's discussions in the email notes and in the file about wanting to get the insurance company moving, about wanting to take.
Stop, full stop. Once again, we have the issue of people talking over each other. So
I apologize.
I accept your apology. So there's a question before the witness.
I'll let you finish.
Okay, let's go back on the record. Rafe, please. The witness will be allowed to finish his answer.
There was a point where there was, I think there was a point where there was 23 depositions requested or something like that. And I thought it was by Mr. Bolasina. Now, the file's huge. So, let me know if you've got a document that shows otherwise. But there were also requests for depositions of 30B6 people so that the insurance issue could be resolved. And I believe that those were actually set and then canceled by Philadelphia Indemnity. So where in the file, I mean, it's a large file, but and then I do recall seeing this statement where Mr. Bolasina, trying to remember exactly where I saw it, but said to Mr. Cochran, can you help me get these guys moving? And it's not, my read of the file is that it's not a situation where, Bolasina was just laying down on the job and not doing his job. And go beyond that, both Ashbaugh and Myers, when they got involved, were also talking about the fact, and I think that Ashbaugh wrote a letter to Philadelphia and said, this case has a large, you've got large exposure. It's horrible abuse. There's a number of kids involved, and this is one that you should settle. And I think that was after the 3.95 settlement offer had been made. So, yesterday you objected to me talking about this, so I was a little bit careful. But it's very clear to me in going through that file when you read it that the desire to defend the case was there, but that their ability to defend the case was not given to Mr. Bolasina.
Have you reviewed Mr. Bolasina's deposition transcript in preparation?
I did at one point prior to my deposition, and if you can direct me to a page, I'm happy to look at it. But this is my feeling from the whole file.
Well, the question is, you don't remember anything in his deposition where he blamed Philadelphia for not being less prepared than he wanted to be?
Well, I remember it in the file, so I don't. In the deposition, I don't recall specifics of that deposition right now where he blamed Philadelphia.
You didn't blame him at all during his deposition, did you?
Well, as I said, I don't recall specifics where he blamed them.
You said that there was a dispute over the policy limits.
Yes.
What do you remember about that?
Well, there was a question whether it was 4 million or whether it was 1 million. And I believe that there were efforts to get a mediation going to discuss that issue, that Philadelphia Indemnity initially agreed and then refused to go to the mediation. And then they filed a deck action, and their contention was that it should be $1 million, and the issues with the plaintiffs where they felt it should be 4 million. And I think that issue is still unresolved at this point, but I know what Judge Layton ruled, and I don't know if it's been appealed, or I think it has, but I think it's still an unresolved issue.
Okay. What's the status of the district court action?
I believe it stayed, but you can correct me if I'm wrong on that.
That's my understanding as well. So, did you review the deposition transcript from the Olympic Early Learning Center 30B6 with Mr. Steve Olson?
At one point I did, correct.
What did he testify about in his deposition on behalf of Olympic, what he believed the available limits were under the policy to settle these 6 cases?
I don't recall that offhand, but I do know that Mr. Olson and Mr. Ashbaugh's declaration talked about, look, we want coverage, and my wife and I don't want to be left out in the cold without coverage, and that's what's happening. So, Mr. Ashbaugh, would you help us? And then Mr. Ashbaugh made the letter, wrote to, or I don't know if he wrote or called, but to Philadelphia and said, settle this thing at the 3.95.
My question is, during the deposition, what did Mr. Olson have to say about what he thought the available policy limits were?
I wish my memory were good enough to remember every line of every deposition, but unfortunately it's not.
Fair enough, but you understand that at the time of his deposition, Mr. Olson was saying that the available limits were also, he agreed with Philadelphia that they were $1 million.
Objection, it's asked and answered, Your Honor.
Overruled.
And I would go beyond that. I would say that whether or not a client agrees with what the policy limits are is, in my mind, relatively unimportant. Mr. Ashbaugh, when he got involved, was talking about it at the $4 million limit. And so, what Mr. Olson, to my understanding, is not an attorney. And I don't know what his assessment of the policy limit would be.
Well, most insurers are not attorneys, but you have a situation here where both parties to the insurance contract, the 30B6 representative of Olympic and the insurance company, at that point in time are agreeing the policy limit's $1 million. If both parties to the contract agree that it's $1 million, why is that unimportant?
Because the question is, what does that policy what is the insurance coverage? And my read's a little bit different than yours. My read was that Mr. Olson was saying, my wife and I don't want our personal assets on the line, so get this settled. And then I believe Mr. Ashbaugh came in and spoke and became the attorney for Mr. Olson. And Mr. Ashbaugh then looked at the issue and wrote to Philadelphia and said, settle this at the 3.95 settlement offer that had been made after a year of going back and forth on this.
Okay. Mr. Cochran filed a separate lawsuit against Eli Tabor. Remember that?
Yes.
Do you know why he did that?
I've done that myself, and the reason for that is to be able to get the records. I mean, a lot of times you don't have subpoena power with a perpetrator until you file. We've done that in cases where it's difficult sometimes because of HIPAA and so forth. So you need to get those records.
What records are you referring to?
Well, medical records, any background records, particularly. And I think he was over the age of 18 here, and certainly in a case with a juvenile, you need to file some type of action to get that subpoena power. But even with an adult offender, to get past HIPAA laws and to get the records, a lot of times you need subpoena power.
But you could do that by adding him to the lawsuit that was filed against.
That would be a mistake.
My question is, can you get those records if you included Eli Tabor in the lawsuits against Olympic or?
And my response is you'd have the subpoena power, but that would be a major mistake under current Washington law.
Why is that?
Because Tegman would then come into play. Without the perpetrator included, there's no Tegman instruction. We talked about that yesterday with Judge Downing crafting the Rollins instruction that is now the operative instruction. And so now it's actually a mistake to include the perpetrator in a lawsuit of this nature.
Now, yesterday I thought you said that Tegman was out. Now you're saying that back in 2012 that would have been a mistake because of security.
Tegman is out in a case where there's not a perpetrator named. So if I bring a case, and we do this a lot with, particularly with the DOC cases, and I name the perpetrator, so I've got the at-fault and negligent party and the perpetrator, which is the intentional tortfeasor. When I include both of those in the case, then a Tegman instruction, the defense can ask for a Tegman instruction. When I don't include the perpetrator and it's only focused on the negligent party, then it's a Rollins instruction. And that's the work that Judge Downing had done.
What's the difference between the Tegman instruction and the Rollins instruction and how it operates?
The Rollins instruction inverts Tegman, but essentially you've got a case where it says that, I don't remember the exact wording, but you can allocate fault. Tegman is you split the fault between the two parties. Rollins is that allows you to give fault if you desire to the perpetrator.
So if, in this case with Mr. Tabor, a defendant in his own separate case, what would the Rollins instruction say to the jury in the case against Olympic and the two individuals?
Well, the Rollins.
In terms of allocating fault or considering fault.
Jury could, if they wanted to, allocate fault to an intentional tortfeasor, but to those tortfeasors that they feel are responsible. But it's the way the Rollins instruction is written is the case then focuses on the negligent party and not on the perpetrator, and juries do not, they don't split it between intentional tortfeasor and the negligent tortfeasor. That's the purpose.
You can only speculate what a jury would do in this case, correct, without allocating fault or looking at the causation issue and differentiating between damage caused by Tabor as opposed to damage caused by the alleged negligence.
No, well,
You gotta let me finish.
okay,
I'm trying to let you finish.
sorry.
Did you get my question?
Well, you're asking whether I'm speculating about what a jury would do. And having been through a number of these cases, I think it's not speculation. It's the purpose for writing the Rollins instruction. And what happens then is the jury focuses on the negligent party to the exclusion of the tortfeasor. I have seen a number of closing arguments where there's an attempt to draw that focus away and so forth. I have not seen a successful one yet. And so it's, when you ask me, is it speculating? I don't think so. I think that that's the reason for the Rollins instruction. I think a lot of people felt Tegman was wrongly decided, and I think Rollins, to a great extent, cures the problems that Tegman caused.
Okay, I'm gonna ask you to put up the little timeline that I have for the I want to shift gears here a little bit and look at the events leading up to the covenant judgment settlements. And I've got a date of 9/24/12 there at the end for the covenant judgment settlements, but you seem to think it was a different date.
Wait, say that again?
On the last, I've got it, I've got the date. Oh, I don't have the date. I'm sorry. What are the dates of the covenant judgment settlement?
I thought they were started on the 9th. There was one that was on the 19th, I think. Then I think there were some that were on the 20th, and I don't recall the date. I think there were some that were later too, but I think they started on the 19th, went to the 20th, and then were later as well, if I recall correctly.
Okay, so starting at the top, in July 2012, there was an offer or demand for $4 million from Mr. Cochran's firm to the defendants. Does that sound clear, that demand?
The only thing that I'm going to question, it's not on your chart, and that's what I was looking for my chart, but I believe that there was initially a demand made only to the Olympia Early Learning Center at $4 million, and that there was negotiation between the parties, and I think that demand then changed. So, and I think the negotiation started actually before that, and everything I'm talking about as far as the attempts to figure out coverage, which both parties at that point were involved in, I think started back in October of 2011 or even before.
Prior to 7/19/2012, did Philadelphia agreed to participate in a mediation?
My understanding is they agreed to participate and then they withdrew. I don't think the mediation ever occurred.
What were the plaintiffs' feelings about going to mediation by the time you got to 7/19/2012?
I know that there was a desire to go to mediation. I think that Mr. Bolasina was asking for assistance in getting to mediation. It's my understanding that the mediation was something that people wanted, and that's my understanding.
Isn't it true that when Philadelphia agreed to go to mediation, that plaintiffs definitely said no?
I'm not. By 7, I'd have to have the dates of agreement and disagreement. My understanding was that there was an attempt to get mediation scheduled.
By who?
I think both sides, but it was my understanding that Philadelphia withdrew and then filed a deck action.
Where's that understanding?
The fact that they didn't mediate, that they withdrew, and that they filed a deck action.
What are you relying on for them withdrawing from their agreement to mediate prior to 7/19/2012?
They, well, you're asking prior to 7/19. I don't recall the specific dates, but I do recall requests for mediation and that there was not a follow through by Philadelphia. I also believe there were requests for 30B6 depositions, and I think that those were agreed to, and then they were unilaterally canceled by Philadelphia.
You testified about that. My question is, I'm asking about 30B6 depositions in Philadelphia. That's what I'm not asking about 30B6 depositions. In Philadelphia, I'm asking about the willingness to go to mediation in the few months leading up to 7/19/2012.
Well, it's my belief, and if you've got something that says that's wrong, it's my belief that the plaintiffs wanted to mediate and that the Philadelphia did not want to mediate.
Okay. A month later, the name went down to, it's actually 3.95 million. I've got 3.9 here, but you know, that's about a month later.
Right. It's.
Why did it go down, you know?
Yes, because I believe it was because Mr. Ashby asked that the additional amount be left on the policy in the event of any further lawsuits. It's the reason attorneys typically do that, defense attorneys, is because it triggers the insurance company's obligation to defend.
Right. So once the policy is exhausted, there's no longer defense obligations. So Mr. Ashbaugh, protect his clients, wanted to leave a little bit on the policy to make sure that there's a little bit left for ND perhaps.
Correct. I'm not necessarily.
And also a defense for the insurance against the claim by ND.
Right. I'm not going to agree with the preface of your statement that there's no longer an obligation, but I will. I think there's arguments both ways in that. But can you state the rest of the question?
Well, the question is that you wanted to leave a little bit of money on the policy. So there could be a little bit left for ND if ND was ever interested in pursuing the claim. And still be an ongoing defense obligation.
Yeah, and where I would disagree with that, it wasn't just for ND. There had been a pedophile in this daycare center or learning center, and there was concern that there could be other kids that had been molested as well that could come forward.
Sure. So, but it would leave $50,000 available. If for all those other claims, is that the idea?
I'm sorry, I missed that.
There'd be $50,000 for all those.
Correct. The answer to that is I don't want to, that's going to depend on the coverage issues. But what was most important there is that it left an obligation to defend, and which is a huge part normally of an insurance policy.
Sure. Can you describe real briefly your understanding between defending under a reservation of rights and defending without a reservation of rights?
Reservation of rights says that you may have some policy defenses, but you're going to provide a defense.
Okay. How about there's no reservation of rights?
If there's no reservation of rights, that means that you're going to defend.
Okay. And pay.
Uh,
To the policy limit, correct?
It should mean that.
That's what it means, right? Under the law, that's what it means.
That's correct. I mean, it should mean you provide a full defense and that you agree to indemnify.
And in this case, did the Philadelphia ever issue a reservation of rights?
I don't believe a reservation of rights letter was sent in this case.
Okay. So they were defending without a reservation of rights, correct?
Correct.
And they were legally bound, and they knew they were legally bound to pay whatever the judgment was at the end of the day up to the policy limit, whatever that policy limit was,
And to provide a full defense.
and to provide a full defense.
Right.
So, so after the 3.95 million offer was sent to the defendant, 3 days later, the interpleader was filed by Philadelphia. Is that your understanding?
That is my understanding. I'm trying to figure out with your dates, because I believe that it was during that, you've truncated it and taken out a number of earlier dates, but I believe that Philadelphia quashed the deposition at that time. And then I think that there was a letter or email from Balacina saying, I'm not sure how to get these guys to respond. So I think there's much more to this story than is being shown in this little capsule.
Okay, well, I'm sure Mr. Cochran can ask you about that.
Okay.
But, and it seems like you're telling us anyhow what you know. But you would agree that the interpleader was then filed 4 days after the 3.95, correct?
I'll accept that.
Okay. At the time the interpleader was filed, Philadelphia know that there was a covenant judgment settlement in the works.
I don't know if they knew that or not. I do know that that was after the discovery cutoff. And I do know that at that time, as I mentioned, the attorneys were trying to get them to respond, and we're starting to talk about what do we do with an insurance company that's not providing a defense.
They were defending under a reservation, without a reservation.
They were not defending, though. They were not, there was the ability to retain experts, the ability to take depositions, the ability to depose witnesses and so forth was not provided. There was not a defense being offered. I mean, for a case of this magnitude to go forward without these things occurring is not providing a defense that you're contractually obligated to pay. There was not a defense being provided.
Okay, we understand your position on that, but
Okay.
there was no reservation of rights. Correct.
I've said that there was, to my understanding, there was no reservation of rights, so a defense should have been prevented. That's why I do believe, and this is different than what we were allowed to say yesterday, but that's why I believe this is a very serious bad faith case.
Okay, we're not going to talk about bad faith. Some of these facts are relevant here, and you've already testified about your position, and
Okay.
we're going to hear from Mr. Balacina, and we'll see what he has to say about this.
Fair enough.
But moving on here, what did Philadelphia ask the court to do in the interpleader? What's your understanding? Have you read the interpleader complaint?
I did before my deposition, and basically, I mean, the basic thing is to determine the policy limit. Philadelphia wanted it to be only $1 million. They did not want what they called stacking of the policy of the different years.
So there was 4 years of coverage, and there was an anti-stacking provision. But one of the questions in the interpleader was, does it apply?
Correct.
Okay. What was the case law at the time?
Well, Judge Layton ultimately ruled that they couldn't be stacked. I think, I mean, if you're asking my interpretation, I think there should have been a $4 million policy. And that's why I say it's still an open issue. But I think it really is the timing of the events and so forth under the language of the policy rather than the question of you trying to stack.
Judge Layton didn't agree with your opinion.
Judge Layton and I don't always agree.
So the basic idea of the interpleader was, by Philadelphia was, we had this dispute, we think it's $1 million. The defendants think it's 4 million. I'm sorry, the plaintiffs think it's 4 million. And please decide what the policy limit is. And we'll live with your decision and we'll pay according to whatever you decide. We'll let you, we're asking you to divide it up among the potential claims.
That's essentially it, except Philadelphia also fought off the depths where people could, which would have been very helpful in that action, but
Sorry, Philadelphia
fought off the debt. I think there was motions to quash the debts.
There would be depositions in the interpreter action, correct? Just got stated.
Well, ultimately, yeah, but remember, you're past the discovery cutoff in the action that's pending, and you're coming into trial, and you've got people trying to figure out what to do when they're coming into that trial. And I mean, this is all, everything here is last minute by Philadelphia.
So 4 days after the interpleader action is filed, the defendants received a $25 million covenant judgment settlement demand. Correct?
Interpleaders filed 8/24. First, did you say 4 days after it was filed?
Saying that 8/29/2012, Mr. Bolasina received a package of pleadings that
Okay.
asked him to consider and get his client.
I'm trusting you on that date, but it was, I know they were entered into in the 19th of September, so they were provided sometime before that. I know it was after the discovery cutoff as well.
And when in this timeline did Philadelphia find out that parties were working on a covenant judgment settlement?
Well, generally, that's something that happens as it's going forward, and generally it's something that a insurance company should be aware of if they're paying attention to the case.
So my question is, when in this timeline, Philadelphia?
I would say, I don't know the exact answer to that. I would assume it was sometime probably after they were entered into.
Okay, and at the same time that the covenant judgment settlements were offered, call it settlement demand here, Philadelphia had already filed the interpleader, correct?
Correct.
And had already agreed to let the court decide this dispute about the policy limit and agreed to pay whatever the court decided.
That's, I would interpret it a little bit differently. It was a last minute filing. There had been no defense provided. Philadelphia wanted to get it down to $1 million, and they were ignoring the obligations to the insured and hoping that they only had to pay $1 million and not providing the defense, thinking that at worst they'd have to pay $1 million. That's how I would interpret it.
Okay, and then on 9/19, Philadelphia made the $1 million, after filing the interpleader, again made the $1 million policy limit.
Right. I mean, they made this 11th hour. Yeah, I wouldn't even say 11th, 11:59 attempt, but the parties were negotiating to try to protect their insureds at that point.
We talked about those negotiations, but and then about 5 days after the $1 million limit was offered by the defendant, the covenant judgments were finalized.
Well, no, I don't think that's right. 5 days after, I think that my understanding was that the $1 million, the last minute offer, I thought it was on 9/19, but in that the covenant judgments were being done on 9/19, 9/20, and thereafter. I don't remember the date of that after 9/20.
The number of days between 8/21 and 8/29, that is between the time the 3.95 offer came in and the $25 million covenant judgment settlement demand was 8 days or 9 days, correct?
The number of days between 8/21 and 8/29 is 8 days.
In that 8-day period, the settlement offer, 3.9 to 25 million.
Correct. Because, yeah, there was no response, so the parties began to enter into a covenant judgment. I mean, that's what happens when you do a covenant judgment.
Well, the only thing that happened was in between those 8 days was that the interference.
No. During that time, there's discussions going back and forth with the parties. Ashbaugh is dealing with clients who do not want their individual assets taken. I think the board at the OELC didn't want the building to disappear. And so there's a lot going on. I mean, the concern by the clients, the insureds, and the attorneys was that they were being sold out to Philadelphia Indemnity's desire to hold its exposure down. And so they were negotiating, trying to figure out how to protect their own personal assets and the school.
That all those discussions took place in that 8 days.
Well, they ultimately signed them on 9/19, so it was during that period that all those discussions were taking place.
During that 8 days.
Well, it was between 8, let's see. It would have been during that entire period that the little capsule that you've got up there of time, they signed them on, as I mentioned, on 9/19. So they are, and I think Ashbaugh, I believe that he contacted Philadelphia, I want to say shortly before the covenant judgments were signed, and he was trying to get Philadelphia to pay attention too, and they wouldn't do it.
You know what the rule is in federal, when you file an interpleader in federal court in 2012, do you know what the rule is about putting money in? You have to actually deposit money in the court to file an interpleader.
Okay, fair enough.
Unlike state court.
Sorry.
Do
you have to actually deposit money?
Why don't you just tell me the rule that you're referring to?
I don't know the rule, but I'm asking you whether or not you're understanding that an interpleader action in federal court, when you file it, whether or not you have to also put money into the registry.
My response would be, in an interpleader, you normally interplead the fund. So I don't know the exact rule, and it sounds like neither one of us do, but technically an interpleader is the interplead.
Okay. You understand that Philadelphia, in following that, would agree to pay whatever the court said the policy limit was?
Well, I would assume. I mean, they're not going to tell the court they're not going to pay it despite what he decides.
So in that 8-day period, somehow the settlement value beginning with $4 million, $3.95 million, and then went up to $25 million in 8 days.
Well, the difference there is that it's not a value of the case change. The difference is that you've got one that's limited by what the coverage is believed to be, and then there's not a response, and so then then it's put in at the what we call the covenant settlements. What they do is they offer, and this was also negotiated back and forth, but they offer the defendants the right to not have their personal assets. They give them a covenant not to execute, and then they put the judgment in at the amounts that we've been discussing through the case, and then they take the risk upon themselves with regard to proceeding forward against the insurance company.
What I'd like to do is go through the Chelsea factors, if you could put those up for me. And while you're doing that, Let me ask you a question. You represent a lot of plaintiffs in these kinds of cases.
Correct.
You always make a policy limits demand. You almost always make a policy limit demand.
I almost all, yeah, I mean, I think we virtually always, in a case like this where there's no defense provided, you've got additional factors, but yes, the answer to my question would be yes, or my response would be yes.
Why do you, and at the time you make that offer, the settlement value in the case is policy limit, correct?
No, it's all that you can achieve. I mean, there's a lot of times that you will make a policy limits demand, and particularly when you've got an insurance company that you feel is not paying attention, and you, I mean, to be honest, you hope that they'll continue to ignore it so that you can get the true value of the case.
Settlement demand, the settlement value based on ability to pay at the time you make a policy limit settlement is policy limit.
That's the most you're able to recover if the insurance company is paying attention and if they accept it.
And if they accept it, then you've got a settlement for the policy limit.
If they accept it, then you resolve it at that policy limit, correct?
You know whether plaintiffs in this case ever made a $1 million policy limit settlement demand?
It's at this point, I think the insurance was not resolved. The insurance issue was not resolved. I don't think there was ever a $1 million policy limits demand made. I think it was made at 3.95.
Okay. Thank you. So I'd like to go through the Chauncey factors and see what happened to make the settlement value of the case go up over an 8-day period from 3.95 million to 0.58.
Objection, Your Honor, that
Sustained.
mischaracterizes his testimony.
I apologize to the court reporter and to the parties for interrupting. I'm sorry. The objection is sustained. That's testimony. But you may ask a question, Mr. Levison.
Okay. First considering the releasing person's damages. So damages are damages. The plaintiffs in this case, their damages, how they were damaged, that didn't change in that period, correct?
It didn't change in that 8-day period, but at the beginning of that 8-day period, they were huge, which is why the insurance company was, gambling with its insured's, assets and playing with fire.
You'd agree that the damages, whatever they were, didn't change in that 8-day period?
No, I don't believe in that 8-day period that the value of those claims changed.
I'm not asking about the value of the claims there. I'm asking about the plaintiff's damages.
I'm searching for your.
I appreciate your testimony that the value didn't change in that 8-day period. Under this Chauncey factor, are you agreeing with me, just to be clear, that the damages did change?
I'm saying that the damages, the settlement value is 25 million, and in that 8-day period, it was always I think it's higher than that. So let's say it's 30 million. Let's say it's 40 million. During that 8-day period, it did not go from 40 million to a different figure.
You're agreeing with me. Whatever the damages were, they didn't change in that 8-day period.
I think we're saying the same thing. When I'm talking about the value of the case and the damages, then I think we're saying the same thing.
Well, value of the case and damages, two different things. And you think they both stayed the same? Is that your testimony that they both stayed the same?
Objection, Your Honor, to the form of the question. I didn't understand it. Maybe.
The objection is sustained. The court will ask Mr. Levison to reframe the question, please.
Are we both agreeing that the value of the case and the damages both did not change in the 8-day period?
I think so. I don't know if what I'm saying is what you're understanding, so I may not be being clear, but What I'm trying to say is that on the beginning of that 8-day period, you had a $40 or $50 million case. At the end of that 8-day period, you had a $40 or $50 million case.
Did the theories of liability plaintiffs had against the defendants change in that 8-day period?
No.
Did the merits of the defendants' defenses, affirmative or defenses to the claim, anything change in that regard during that 8-day period?
I don't think this case was ever defended until this proceeding. So there was essentially no defense. So the answer to your question is during that 8-day period, no, but I think the defense is being put on in this proceeding now.
Okay. But there's no change, whatever it was, that didn't change.
That did not change during that period of time.
Okay.
Well, let me hesitate on that a little bit. There were letters from Mr. Ashby. There was attempts to get Philadelphia to pay attention, and I think some of those occurred during that 8-day period. But I can't recall exactly the date when Mr. Ashby contacted Philadelphia, but he told him that it was a major case, that they should be paying attention, and they should. I think his exact word, it was something like this abuse is horrific, and I think he told him about the $8 million judgment that Daryl Cochran had gotten, and basically told him they should settle.
That answer has nothing to do with the question I asked you.
Okay, sorry.
You would agree. I understand you're an advocate here for your clients, or for the people that have hired you. I understand that, but that wasn't have anything to do with what I asked you.
Objection, move to strike the preliminary statements.
The question with respect to being an advocate for your clients is stricken. The question before the witness is well, let's have another question, Mr. Levison, please.
Thank you, Your Honor. You would agree that nothing changed in that 8-day period with respect to the posture of the defense?
I'm not gonna agree with that, because I do think that there was I think that there were actions being taken by the defendants to try to get help, and I think information was being given, and attorneys were looking at oh, you took your capsule down, but I think attorneys were being hired who are now looking at the case for both Rose Hordahl, for Steve Olson, and for the Olympia Early Learning Center. I think they were now looking hard at that case, and ultimately, whether it was in that 8-day period or not, made contact with Philadelphia and said, get this thing settled. You're facing a major, major case.
What about the defense theories in the case changed during that 8-day period?
Well, you had attorneys coming in and looking at that and saying that, one, the case hasn't been defended, and two, we're in trouble. You're in trouble to their insurance, to their clients.
That has nothing to do with, I'm not sure that answers my question. My question is, did the defense get better or worse during that 8-day period based on the merit?
I think it was recognized that the defense was in trouble. And so did the defense get worse? I think there was greater recognition that the defense was non-existent and really bad.
During that 8-day period?
Well, your time capsule is trying to force me into, so I'm going to say during the period when the new attorneys were getting involved and reviewing the case, and I think it encompasses that 8-day period.
Okay. The released person's relative pulse, did that change at all during that 8-day period?
The released person's, no, I don't.
Yeah, Your Honor, let me object because I think we stipulated yesterday that this is a non-issue.
I think that's accurate.
Okay. But that didn't, my only question is that didn't change.
Same objection.
Overruled.
The relative fault, did it change? No, and when you use the term relative, I mean, the fault was huge. The plaintiffs were fault-free.
The risks of and expenses of continued litigation, did that change during that 8-day period?
Well, yes. I mean, that's where the attorneys were coming in and trying to address that to minimize the risk for their clients and minimize their loss of assets and minimize the expenses. I think, and you can correct me if I'm wrong on this, but I think that what happened was that they had to pay the costs of Ashbaugh and Meyer. I don't think those costs came out of the policy. I think Philadelphia Indemnity was paying Bollicina, but now the insureds not only had to put their assets were at risk, but they had to also pay attorneys because they weren't getting the defense that they were contractually required to get.
There weren't significant expenses incurred during that 8-day period.
Well, I mean, attorneys are not, they're not cheap, and particularly for lay people. I know, for example, that I've read in the file somewhere that Mr. Olson and his wife were quite concerned about, and you get to a point in life where you don't want to lose your house, you don't want to lose your assets. I mean, those are important to people, and whether it's a $200,000 house or whether it's a $10 million mansion, it's
My question was really focused on.
well, let me finish. It's that person's castle, and they don't want to lose it. So you can say, well, Ashbaugh and Myers weren't charging that much during that time, but it probably was a significant amount to the Olsons. I mean, that's my thought. I don't know what their assets were and how much money they had, and then I also know that during that time that the board at the Olympia Early Learning Center was concerned. They didn't, there was all this talk about, I think the building's worth $150,000 and maybe there's a little bit of idea through the file that's so big deal, you lose the building, but the board didn't want to lose that building. And they thought they had bought insurance that would help them out so they didn't have to lose it.
And all that analysis took place during that 8-day period?
Well,
Let me back up. My questions really go to the change during an 8-day period. And I think you've already testified about everything you've been saying. But I'm trying to ask you about what changed between the time when the case was worth $3.95 million and the time it was worth $25 million.
And what I'm trying to say, and I'm not being clear enough, clearly, but there's a lot going on during that period. And if you ask me, you keep saying this 8-day period, but the period when all this is going on encompasses that 8-day period. You have people that are struggling to, because they're not being indemnified, because there's no defense, they now see a huge lawsuit coming down the pike, and they're struggling to preserve personal assets, a school, and so that's happening during that 8-day period. I mean, I feel like I'm trying to be forced into a little time capsule that I think there's a lot more before that time capsule. But
that's a good point, because most of the things you're saying were happening before the 8-day period. And you're just saying that. And
during it. I mean, it's, the covenant judgments were not entered, those were entered into, and initially there was going to be covenant judgments, and then there was negotiation that went on to get the I believe the covenants not to execute were not initially included in those. And then through negotiation, I think the covenant not to execute were included. I'm reaching a little back into my memory, but I believe that's the case.
There's no negotiation over the $25 million amount.
Objection.
Well,
Hang on. Overruled, if you can answer it. The question is, there is no negotiation over the $25 million amount, was there?
and I disagree with that. We talked about that yesterday. But my read of the file is starting back in negotiations started back, I think, 2011. I'm going to say, October, November, December, there's discussions going on. There's attempts to figure out the coverage. There's attempts to get Philadelphia to have 30B6 depositions, to have mediations. And that's all going on for, I'm going to say over a year, but roughly a year beforehand. And then what we're talking about, when yesterday you were asking me about, then there's a take it or leave it. Forget what word you used, but what was the word you used?
Take it or leave it.
You used a word that kind of like hardball offer. And
Hard bargain.
I think you said hardball or something like that. But
I said hard bargain. You're asking me what I said yesterday. I said hard bargain.
I'm going to say it was hardball. But anyway, and I'm saying that's the end of the negotiation. That's, and that always happens in trials. You're negotiating, you're trying to get things worked out. You've got requests to mediate. You've got requests at 4.95. Then there's finally and then you've got people coming in and new attorneys coming in, and there's discussions about adding in the covenant not to execute, which is a negotiation, and that's to protect the clients. And then finally, after discovery cutoffs, and I think I'm going to say 2 to 3 weeks before trial, then you've got your offer that says, look, we're now going to trial unless you agree to these. So I think it was the end of a year of back and forth, and I think the file confirms that.
I'm not sure you answered my question, but I'm going to move on.
Okay, I'm happy to try again.
One of the risks after the interpleader was filed within that 8-day period is that now there was an action filed to allow a court to determine whether the policy limit was 1 million or 4 million. Correct.
The interpleader was filed, and the interpleader requested the ruling that we've talked about, but it's a last-ditch effort, and it's not defense of the case that was existing at that point. And that's what's you don't defend a case by, sometimes people file a deck action and so forth, but they think about the timing, and you don't do it 3 weeks before trial. Or the main concern of Philadelphia was not Steve Olson and his wife's assets. Their main concern was, how much money can we keep this down to? And it's very clear from the attempt 3 weeks before trial, after the discovery deadline, to then file an interpleader action.
I'm not sure you answered.
Okay, I'm not doing very well. And I apologize for that, but I thought that one did answer the question. But can you re-ask the question?
Can you read the question? Is there any way I can get you to read the question back? My last question.
Okay, stand by. Question is, one of the risks after the interpleader was filed within that 8-day period is now there was an action filed to allow a court to determine whether policy limit was 1 million or 4 million, correct?
One of the risks. I don't see that as really being related to the Chelsea or Glover factors in the case at hand. I see that as being a separate action. And in the case at hand, the issue was you had an approaching trial, discovery cutoff was done, and you were 2 to 3 weeks out of trial and you had clients that were worried about their assets. I hope that answers the question. What I'm saying is I'm focusing on the word risks and whether that's one of the Chelsea Glover factors. And I don't think that Philadelphia's separate action was really related to that in my evaluation of whether these settlements are appropriate and within the range of settlements.
There's a long-standing dispute.
It was,
Well, let me finish. Policy limits, whether they were 1 million, 4 million. And once the interpleader was filed, it really sort of focused in on that issue. And we now had an action filed to allow the court to decide that. And so even though the plaintiffs believed it was $4 million, they now are confronted with a possibility, if not probability, that a court would come in and say, you're wrong, it's not 4 million, it's 1 million.
Object to the form of the question, Your Honor.
Is that correct?
Overruled.
but how does that help Mr. Olson at that point and his wife, and how does it help the board at the Early Learning Center? And you know, they're going forward. They get a big judgment against them. School's gone, personal assets are gone, or bankruptcies have to be filed. The point that I'm trying to make is, one, I think that it's a little unrelated to this. I do think it was an 11th hour action, but that Philadelphia Indemnity was not working for its insureds at that point. Philadelphia Indemnity was looking out for its own interests, and that's what bad faith is.
Well, I'm still not sure that answered my question. My question really went to, once the interpleader was filed, plaintiffs' belief that we're going to get $4 million in policy limits. The risk that would be determined to be $1 million changed, the risk changed once the interpleader was filed.
No, I don't know if I'm allowed to ask questions, but I'd look back at you and say, well, wait a minute, when was that interpleader going to be decided? That would be down the road sometime. But Steve Olson and his wife were looking at a trial that was coming right up. So what Philadelphia had done by its action is exposed them and the school. And if they then move forward with the case, you know, Philadelphia maybe later gets its determination, but there's a judgment that's entered against Steve Olson and his wife and you know, the board, the Olympia Early Learning Center. And that judgment, a judgment can sit out there for 20 years. And it can cause people to have to go into bankruptcy. It can cause them to lose their assets.
You know if Mr. Bolasina had any plans to ask the trial court to stay the underlying action, the trials in this case, once on the basis that we have this dispute on what the policy limit is. Judge, you wanted us to try to mediate this before we went to trial. We didn't get to mediation for whatever the reason was. We can ask Mr. Bolasina about that some more
Well-
this afternoon. Let me finish my question. And I'm very confident that once we get that answer, we'll be able to settle this case. But we don't want to have to go through a trial until that's decided, because that's the sticking point.
Objection, Your Honor.
There's no question, so let me hear a question and then,
Yeah. You know, if Mr. Bolasina had any plans on that basis that I've just described, to ask the court to hold off on the trials.
And Your Honor, I would move to strike the preliminary comments as they represent facts not in evidence or facts mischaracterized.
granted, and there's a question before the witness. That question is, do you know if Mr. Bolasina had any plans on the basis that I have described to ask the court to hold off on a trial?
The record reflects, first of all, I think it's very unlikely that I don't think the court would say, oh, there's now an interpleader, last minute interpleader action filed, so we're going to continue it. But I think that I remember a transcript in the file, and this is reaching a little bit, and I don't remember who the judge was for 100%, but I think that he basically told Mr. Bolasina it was a hearing, and I think Mr. Bolasina was there by himself, but he basically said, you are going to trial in, was it 3 weeks or something like that? And it's, so
I say that we're going to trial if you have a mediation and it fails.
well, he said, we're going to trial. I think he said have a mediation, but I'd have to go back and look at that. I'm reaching a little in memory, but the point is I don't think that Philadelphia Indemnity can bank on its attorney after the discovery cutoff and 3 weeks before trial getting a continuance from the judge on a case that's been pending and the plaintiffs are ready to go.
My question is, do you know whether Mr. Bolasina had any plans?
I think I've answered that. I don't. Well, he didn't. In my recollection of that hearing, he did not ask for a continuance.
I'm gonna stop, and I apologize. It's 10:20. Court's going to take a 20-minute recess for the morning. Court's in recess until 10:40. Thank you.
Thank you, Mary.
Hey, guys. Now we need-
Stop there. Who is the judge?
All rise. Court is in session.
Please be seated. Thank you. Mr. Lavison, you may continue.
Thank you, Your Honor. I'm going to try to get through the rest of this quickly. I don't think we want you to have to stay this.
All right, thank you.
Factor number 6, the released person's ability to change. That didn't change in that 8-day period.
The released person's ability to pay.
Plaintiff's ability to pay, or the insurance policy. The conflict between policy limit being $1 million and $4 million. Some of that changed during that 8-day period. Correct?
The conflict on the policy didn't change, but there are a lot of discussions going on with regard to the defendants in the lawsuits ability to pay and whether or not they were going to be able to pay. So it actually did change in the sense that they went from being on the hook to having a way to protect themselves.
During that 8-day period.
Well, it encompassed the period that they were looking at those, I think, as you pointed out in that little capsule, it encompasses that period.
Evidence of bad faith, collusion, or fraud. And let me say, nobody's claiming bad faith or fraud. Just limited to collusion. Were there anything changed on the evidence of collusion during that 8-day period?
No, I see no collusion or fraud. I do see bad faith by the insurer.
Factor number 8, plaintiff's case, the extent of the releasing person's investigation and preparation for the case. That didn't change in that 8-day period.
Well, I mean, they continued to prepare the case and they continued to get the case ready for trial. So I think that's always an ongoing process, especially as you're approaching trial.
Tell me what they did to keep the case going, getting the case ready for trial during that 8-day period. What do you know?
Well, I'm saying that, again, it would encompass.
One at a time.
I'm sorry.
What was the full question? I have, tell me what they did to get the case ready for trial during that 8-day period. What could you?
Yeah, just leave it.
Okay, and I'm saying that you've got your little capsule up there, but the period of trial preparation encompasses that period, and I think that I'd have to look at your capsule again. I don't remember exactly the dates, but I believe that during that period, the discovery cutoff, I think, had just concluded, I think, and so during that time, you're starting to look at, getting witnesses. I mean, there's a lot to do to prepare for a trial, especially in a case like that.
Yeah, well, the reason for the 8-day period is because at the beginning of that 8-day period, settlement value according to the offer that was made was 3.95, and at the end of that period, settlement value based on the offer that was made was $225 million. That's the reason. That's the only reason for the capsule, for the 8-day capsule.
Okay, and
all these questions I've been asking you have been focused on the 8-day period because the settlement value changed so drastically. And so let me just ask you in a general question, other than everything you've already said.
And Your Honor, I object and I move to strike the soliloquy. It was testimony, not a question.
Sustained. So let's have a question, please.
Question is, other than everything that you have already said, what happened during that 8-day period to justify a settlement value change from $3.95 million to $25 million? And again, yes, we've already got your answers to a lot of it, but how do you justify going so drastically higher over 8?
all right. and I've indicated I disagree with your statement that the settlement value changed. They were looking at the insurance limits, not the value of the case. And you had agreed that those were different things. But during that 8-day period, you have clients, insureds, that are suddenly realizing they're facing a major trial coming down the pike, and they are facing bankruptcy. You've got an insurance company that is not responding, didn't allow discovery, and at this point, what's changing is that they're looking for a way to protect themselves. They've hired attorneys to do that, and they've taken the necessary steps to protect themselves from all of those things that we've talked about, all the adverse effects of having a major judgment filed against you. So the value of the case didn't change.
Thank you. You testified yesterday about you settled the vast majority of the claims you handled in the sex abuse.
I'm sorry.
You settled virtually all of the cases.
Virtually all of them, yes. Ever since, really the Boys Ranch cases, which, and then, we had McMahon, we had McFarland that did go to verdict, and then the Boys Ranch cases. And after that, I think virtually all of them have settled. Most have settled.
Okay. I mean, your office actually has settled a fair number of cases.
I know that Philadelphia has been on cases, so I don't know the number of them that have settled with Philadelphia. I don't retain that after a settlement.
Some of those cases settle for more and some settle for less. Would you agree with that?
Some settle for more money and some settle for less money. Is that what you're asking?
Yeah.
They settle at different values, correct?
And what is the average value of a settlement that you've had with the cases you've had with Philadelphia?
I don't know.
I'm going to object, Your Honor.
He's already answered the question. Question stands, the answer stands.
I would like to go through a spreadsheet that has all of the settlements that the Connolly Law Firm in Philadelphia.
What's that?
And,
I'll ask you permission before.
and may I be heard, Your Honor?
Yes.
Per, I believe it's the Albrecht case, that looking at settlement values is not the appropriate way to determine reasonableness. I think this exercise has very limited value. All cases are different. Mr. Connolly has said that himself. So I think this exercise is, one, unnecessary, and two, shouldn't be allowed per the case law.
Mr. Levinson?
Your Honor, you heard a lot of testimony during direct about all of a number of high verdicts in these cases. It's our position that actually verdicts aren't relevant. What's relevant is other settlements. So how could other verdicts be more relevant, at least even if the court were to consider the other verdicts? I mean, obviously you've heard about some very high verdicts. You haven't heard about the low verdicts. You haven't heard about any of the settlements. And so this hearing has determined the value, the settlement value, not the verdict value of the case, the settlement value of the case. And so I think this witness has already opened the door by testifying about some very high verdicts. What we'd like to be able to show is that when the cases are settled versus going to verdict, that the settlement values, and the range of those values, they do vary, but they're nowhere near the numbers in this case. Purpose for putting this in.
And if I may.
The court's concern is that perhaps this witness cannot authenticate or confirm or dispel / deny the contents of any proposed or proffered document in the form of an exhibit. So,
We just, let's be to the exhibit. It's a spreadsheet.
the objection is overruled. I'll allow some limited line of inquiry in this regard.
Thank you, Your Honor.
And Your Honor, I understand your ruling. Just to make a record, obviously, this was not discussed at Mr. Conley's deposition. We haven't seen it, and we'll have to. No, I'll leave my objection. I'll leave my making the record at that, Your Honor.
Understood.
So these are this is compiled from the records that Philadelphia has in cases they've settled with your firm. And the highest settlement was 1.2 million. The lowest settlement was 23,750. And to do the math, the average settlement is $269,000 and a little bit. Is this consistent with the range, settlement ranges that you're aware of? And so
No, and I'm trying to read this. What is the second says inappropriate?
Would it help the witness if the witness were to approach that exhibit and get closer to it?
It might.
And I'll ask the witness to testify in the direction of the court reporter so that court reporter can hear.
And I'll go through them one at a time if you'd like, but the first case was a 2016 case. You understand that the settlement at issue was in 2012, but settlement values didn't go down over the years. I think you've already testified about that.
No, I have no idea of these two cases, but I don't believe. I wish I knew what cases they were.
To be honest, we have that information. We've redacted initials because of the confidentiality concerns.
I've got to say, I don't believe this chart, but because this one has my name on it. I have no recollection whatsoever of any case that ever settled for 23,750 back in 2012. I have to say, I don't know anything about this chart. I mean, it's, what I want to do is go back and look at the reasons. Mr. Beauregard handled that one. I mean, as an example, this one, it's the right one, and I don't remember it, but I think it was a prisoner. And I think there were a lot of huge problems with that case, but that one I have a slight recollection of it, the same issue. There were a lot of problems with that case. That one I don't remember. These, I really doubt. I don't think that's accurate. I would have to look at it. Maybe there were other defendants in the case. I would actually wonder on each one of these, were there other defendants in the case? So I don't, my thinking is that I don't believe this chart. I doubt its accuracy.
Your Honor, given the witness's concerns about the accuracy and given the fact that our case in chief in this reasonableness hearing is not going to end today, I'd suggest unless there's something else that this is not a useful or appropriate exercise.
Well, the witness has testified that, as the court understands it, sitting as the trier of fact, that the witness has questions with respect to the accuracy of that document and/or the witness cannot recall any of the relevant details with respect to any of those cases. So in the court's mind, at least at this point, it's a non-issue unless there's some further line of inquiry on these along this line.
We can reserve this and we can get copies of those settlement agreements to the extent they exist. And give them to Mr. Connolly before he comes back to court. We can go through. Let me just ask a general question. Putting aside the two lowest cases that you say you just don't remember, is this consistent with the ranges, just the amounts of the settlements? Are these settlement amounts consistent with the ranges of the cases you were settling in 2012?
No. I can give examples, but my response to that would be definitely no. The McFarland case, and that was probably long before 2012, came in at 1.3. Excuse me, that was McMahon. McFarland came in at about 6. Then we had, when the Boys Ranch cases were coming in, I remember we had Mullins at 4+ million plus. And those cases were probably averaging $1 million plus, and that was early, that was 90s. And then they started, settlements started going up. By 2012, I know that the home case was in there at around 11 million. And that was, I think, prior to 2012, but I'd have to check that. And then we had on a couple of the Boys Ranch cases, we had, I remember there's a settlement at 12 million. The Jacobs Knoll case, I think, settled around 8 or 10. We had a bad faith case, much like this one with Great America, that came in at 8 or 10. I don't remember exactly the number, but so I don't, there's 2 of them up there that I see that there were huge problems with the plaintiff, and that's sometimes the case. The 23,750, I have no recollection of anything that would be about. But no, I think somebody has chosen those in an attempt to make the settlements look small. I also, the other question I've got on those is who else was involved as defendants, because a lot of the cases that we have, you have 3 defendants in and everybody puts in an amount. So those are my thoughts in looking at it. I can't really say that too much beyond that.
Okay. I understand that you weren't prepared to answer questions about these particular cases, but what I'd like to do is, if we can have an agreement, Your Honor, we do have copies of each of the settlement agreements. And to authenticate these numbers and amounts, and we can get a declaration from Philadelphia that represents all the settlements they've had. They don't know about the settlements from other insurance companies. But with the court's permission, I can move on from this area and submit the actual copies, the exhibits for the court's review. I don't know that we need more testimony about this other than to just authenticate the settlements. We can redact names and such as necessary, and we can work with the Connolly law firm to get those in a form that would be acceptable to submit to the court. And
Well, if what the court is hearing now is that at some point in the future, Philadelphia Indemnity may offer exhibits. If exhibits are offered, the court at the time will hear any objections, but the court will not rule on any offers until such offers are made.
okay, thank you, Your Honor. I'm going to try to wrap this up, Mr. Connolly.
All right.
So you talked a lot yesterday about your highest jury verdicts. And you talked a little bit about your highest settlement amount. And with respect to the jury verdicts, you've given a lot of testimony about how the value, the verdict value of the case goes up and down, but fairly consistently is impacted by the jury's view of passion or prejudice or anger or justice, whatever you want to call it. Remember that testimony yesterday?
I'm going to object, Your Honor, to the form of the question. That was not Mr. Conley's testimony.
Well, it wasn't, but I think the witness understands the question and can answer it. So it's overruled.
Yeah, I'll say, first of all, I don't, you asked me about verdicts and verdict sizes and so forth. I don't generally like to talk. I mean, I don't, I feel like it's kind of boasting, and I don't generally like to do that. And I only answered the questions that you asked. So you're making it sound like I was in here, somehow boasting and talking about those. But
I wasn't suggesting that.
All right.
You were giving testimony on direct about, and in your deposition about juries doing your best to represent your client's interests. No, nothing wrong with doing it, but trying to get the jury angry or heighten their sense of justice, however you want to put it, to increase the value of the thing. You talked in direct about the factors that go into boosting a jury verdict.
well,
Your Honor, and for the record, I need to object to that. The question is unfair and is directly mischaracterizing Mr. Conley's testimony.
Well, the court recalls the testimony from yesterday of this witness. From the court's perspective, the witness's testimony is clear. How the witness characterized jury verdicts in this context. So the court overrules the objection, and let me see if there's a question before the witness.
I can come up with it.
Yeah, come up with it, because there isn't one.
That was really just the preface to the question. Given your testimony about jury verdicts and juries and how they behave yesterday, are you suggesting that Judge Dixon should evaluate 9 Chaucy factors based on what a jury would do or should Judge Dixon evaluate the 9 Chaucy factors without the same passion, prejudice, anger, sense of justice to the jury?
well, first of all, I disagree with a lot of what you just said. But
And I do, again, for the record, want to interpose an objection, and I understand Your Honor's ruling, but again, that is mischaracterizing his directly mischaracterizing his testimony.
Well, the court will note, for purposes of making a record, that this court understands what this court's obligation is, and regardless of what this witness testifies or any witness testifies as to what this court should do, what this court's responsibilities are or obligations, this court will completely discount any such opinion. But the court's going to allow the witness to answer the question. If you want me to reread it.
no, I think I get the gist of
Okay.
it. Let me say this, that in evaluating the reasonable amount of a settlement, one has to be mindful of what a jury verdict could be in that case. And so you look at what is a jury likely to do, and I mentioned a number of factors, given the fact that there is sexual abuse, the age and vulnerability of the victims, the betrayal by the learning center, the depravity of the predator, the lack of policies and supervision, the substantial notice, which this file is replete with, the lack of any effort to protect the children after the notice, and the fact that there was no defense given, and the insurance company would not permit a defense, and that the parental claims are strong. Those are all factors that would lead a jury, in my opinion, to a very high verdict in this case. And so when you ask about certain things, are they going to motivate a jury to give a higher verdict? I think the answer to that is yes. Now, in evaluating or determining whether any settlement is reasonable, one of the things you look at is what is a likely verdict? And given that likely verdict, does it make sense to settle at an amount? Generally, a settlement is an amount that is less than what the potential verdict would be, because you want to, buy your peace.
I'm sorry.
I'm not quite done yet. So anyway, what I did in this case is looked at all of these factors, looked at the damages, looked at the damage reports, looked at the perversity of what had gone on, and the disclosures by the children and so forth. And I actually saw even a couple more last night with MM by daycare employees. But all of those things, and then I look at what is a fair settlement back in 2012, and then look at the issue of, are these settlements within the range of what a fair settlement would be? We're very fortunate in this case because we've got two cases tried in 2012, and one's at 1.1 or 1.2, and the other one's at 8 million. And I do think that that's indicative of a abuse range in 2012. So then I looked at the factors on each one of these kids and their parents. And I looked at the issues of, okay, given all of these issues, do these settlements fall within the range of reasonableness? And my feeling is that they definitely do. And I think that this case, if it went to trial, would go much higher than where these settlements went.
I understand what you said in terms of the Chelsea factor on the strength of the liability. You look at the number of parameters that you just listed to address the strength of the liability case against Olympic. My question is, the next question is, where do you see in any of the Chelsea factors other jury verdicts?
You're supposed to look at, is the settlement value reasonable? Okay, so are the damage, when you're evaluating damages, you are evaluating based on what is likely to happen in a courtroom, right? So you're looking at, when you're about, putting a number on it and so forth, you do it in the context of our justice system here in America and what happens when these cases go to trial. So is it a reasonable settlement? And the answer is, given what happens when these cases go to trial, is that this does fall within the range, all of these fall within the range of reasonable settlements.
I understand it says money. I'm not sure you directly answered the question though.
I think I did on that one.
Damages, well, let me ask you this question then. In the Chelsea factor, the first factor is damages.
Correct.
Do the damages of the children or the parents change based on the abilities of the plaintiff's attorney to do a better job getting a higher verdict versus a different attorney getting a lower verdict number? In other words, is there a difference between the damages in the first factor in jury verdicts?
think that when you're assessing the damages based on jury verdicts, you're assessing the ability of an attorney to put on the case and put it on well. And in fact, and to put it on generally well with a defense. I mean, one of the big factors in this case is there was no defense offered. And so if you're asking, does the amount of the verdict change based on the skill and talent of the lawyer? The answer to that would probably be yes. And in this case, that's something that probably should. I know insurance companies evaluate it. They always have lists of past settlements by a firm or by an attorney and so forth. And had this insurance company been paying attention to its insureds rather than to its own pocketbook, it would have noticed that you had two verdicts in 2012 that were between 1.1 and 8, and by the same attorneys handling the case. And let me say it this way: when Mr. Bolasina said, "Can I take depositions?" when he put in his discovery plan, when he put in that it was going to cost $272,000 or whatever, instead of Philadelphia Indemnity, instead of saying, well, we're only going to lose $1 million, so we don't want Mr. Bolasina to do anything. We don't care about the insureds, and we'll file a deck action and get it down to $1 million instead of doing a defense in the case. What's happening in that case is they are exposing their insureds and the case to a much larger verdict. Does that answer the question?
I don't think it does. My question is, which chassis factor? No. Question is, regardless of what a jury might do, based on the quality of the plaintiff's attorney who's trying the case, or based on the sense of justice factor that you mentioned in any particular jury, how does that change damages, the first factor?
Object to the form of the question.
Overruled.
Say it again. How does it change if you have a skillful attorney that can bring those damages to the jury? How does it change the damages versus if you have someone that is not as skillful and can't?
You're going to have different plaintiff's attorneys. You're going to, with different levels of skill. You're going to have different juries.
But shouldn't you bring the case? I mean, in everything that we're doing, shouldn't we assume skillful attorneys so that the plaintiffs are getting appropriate justice in the case?
My point, I guess the point I'm making, and I'll just ask it as a leading question, you can agree or disagree with it. But you would agree that the plaintiff's damages are the plaintiff's damages, and they don't change regardless of what jury happens to be assigned to the case or what attorney is representing the plaintiffs. The damages don't change.
I think that some attorneys have the ability to bring those damages out, and some attorneys are less experienced or skillful at it. And when you have somebody that is skillful and successful, you're going to get the just damages that the person should be entitled to. So I'm not, I'm saying that there's an element of trying a case and trying it well. By the way, I don't know if I should say this, but on that board, the 3750, I think I know which case that is. I think it was a $16 million judgment for a kid that broke his neck. And the last settlement was for a member of a church that had just been out in the field. And so it was closed off on that $16 million verdict. That's what I think. But not verdict, but it was a settlement. But I'm anxious to check it out. And I'm going a little far afield, but which makes me a little bit doubting that exhibit because I think it's an attempt to make them look smaller than they are. So,
Thank you, no further questions.
all right.
Thank you.
Mr. Conley, let's pretend.
Mr. Fowl,
Oh, I'm sorry, Your Honor.
redirect examination?
My apologies, Your Honor. Back to that exhibit. Let's pretend, well, you didn't pretend, you're going to look at that, but one of those involved a prisoner who was touched once by a car. Would the value of that case be different than the value of a 2 to 5-year-old that was abused 50 times, including sodomy and oral sex?
Absolutely.
Okay, and another question. Was asking you questions about and whether damages change. Damages are one of the 9 factors, right?
Correct.
And damages inform the value of the case, I assume, correct?
Correct.
Okay. And your understanding that the factors need to be viewed altogether and no one factor is determined.
That's the law.
How would your opinion have been different? Who do you think the best defense lawyer is?
I think Washington State has a number of very good defense lawyers, and I think that who would I pick as the best? One of the best. Well, I'll say this: whenever you're in a case against Bill Leadham, you're in for a big fight. I don't know if that makes him the best, but whenever I see his name appear, I always I think, oh my gosh. I think John Justice does a good job and an honest job. I think that I mean there's a lot of good defense attorneys.
Would your evaluation on the cases have been different? And I'm not going to rephrase this, but I'm not looking at individual attorneys. Would your value on the case potentially be different if this case had been fully worked out? We were 3 weeks away from trial, and the defendants had taken every deposition, had identified excellent experts, and had a clear theory of the defense as to each and every one of these cases.
Yes, yeah. If the case had been properly defended, I would have different thoughts about it.
So the damages may not change. I mean, being abused 50 times is being abused 50 times, but your analysis under the 9 factors, right?
Correct. I mean, when it's presented to the jury, the likelihood of what's going to happen is going to be very different, and therefore the settlement value should be very different.
You, in your answer to, first of all, let me ask you a general question. Has anything that was pointed out to you during cross-examination, or any of the I don't think you looked at any exhibits, but anything that you pointed out, changed any of your opinions in this case as to the reasonableness of the settlements in covenant judgment?
No.
And what's the difference between an arm's length settlement negotiation, say midway through a case, and a covenant judgment negotiation 3 months before trial and after discovery cutoff is?
Well, the difference is that it's, during the case, it's the same difference if you have a mediation midway through the case. It's going to be a different mediation in the sense that people are still learning the case. They're trying to figure out develop defenses and present the case. At the end of the case, it's you're about to go into trial, and generally it's you're making the decision: do I go to trial or do I settle the case?
And counsel kept asking you questions about what happened in this 8-day period. For starters, who, after looking at the record, who was responsible for the chaos that was occurring in those 8 days?
Object to the form of the question.
Well,
Sustained.
Okay, let me rephrase it, Your Honor. But let me break it down. This way. And Your Honor, if I am getting into an area you don't want me to get into, just let me know. But I think they opened the door to this. You called it an 11th hour, and I think you said actually an 11.59 hour interpleader deck action. Does filing an interpleader action at the last minute absolve an insurance company for bad faith?
Object to the question, Your Honor.
no.
Overruled. The answer stands. The answer stands.
Does filing a deck action at the 11th hour absolve an insurance company from bad faith?
Same objection, Your Honor.
Overruled.
My answer to that is no, and I actually think it is evidence of bad faith in the sense that most insurance companies would do that much, much earlier, and if they're going to do it. I mean, it's here, it was filed late, it was filed instead of preparing the case for trial, and I think when they saw Bolasina's $272,000 cost for doing discovery, they thought, well, the most we'll lose is $1 million, so let's file a deck action and forget about these insureds.
My third question in that line of questioning is, does making an offer, conditional or not, you understand that this offer, the $1 million offer, was conditioned on it applying to someone our firm didn't represent. Does the last minute settlement offer absolve an insurance company of bad faith?
No.
Okay. And is the timing of when an insurance company takes those actions relevant to that analysis?
Yes, it's relevant because it's when it's made late, it's made after the fact. I mean, it's where its own attorneys are taking steps because the insurance company won't, to protect the insureds, which is their job. And then the insurance company steps in and tries to limit its own exposure. I think that's strong evidence of bad faith. And the touchstone of bad faith is that the insurance company is paying more attention to its own pocket than to its insureds. And that is an indication that it's paying much more attention to its own pocketbook.
And counsel, you'll recall a line of questions where counsel put up the 9 factors and asked you what had changed. Had the risk to the defendants changed during that 8-day period?
The risk to the defendant had not changed, no.
And counsel kept asking you, what's responsible for the difference in the value of the case changing from 3.95 to $25 million. Can you explain to the court why that number changed?
I can explain why it changed, but it's not the value of the case. The value of the case, as I mentioned, is, whatever, 40, $50 million. The demand that was made at the 3.95 was made after negotiation, after discussion with Mr. Ashbaugh about reserving that $50,000. And it was to demand that the insurance company pay the 3.95. At that point, the belief was it was a $4 million limit. It was not, Ashbaugh wrote and said it should be paid and so forth. It was not paid. So then you enter into the covenant judgments. When you're looking at that is the Glover factors and what is a reasonable settlement given everything that happened to these kids. So it's a much different analysis than saying, okay, your coverage is X, we're going to seek coverage, versus these are reasonable settlements for under all the Glover factors for these 6 kids and their parents.
So it really has nothing to do with coverage, correct?
Correct.
Correct. And isn't that the whole point? That if it's not settled within coverage, the case law allows the plaintiff to enter into an agreement for what we call extra contractual damages, right? Washington
law is very clear that when an insurance company is, behaves in this manner, that I think the exact language is something like they're not required to sit out there in the rain or something. And, but they're allowed to enter into covenant judgments to, at the value of the case, at the value of the reasonable value of settlements, because the insurer has not been doing its job.
And did you see anything in this record that suggested, and I think that's where these questions are going, that suggested there was any collusion at all?
No, I don't see any collusion, and I've been through this process a number of times, and I'm aware that attorneys evolved in their reputations and so forth, and I don't think there would be collusion with these attorneys. These attorneys know what they're doing.
And what's your opinion as to whether, I'm sorry.
Well, I was going to say one other thing. You're talking about Mr. Bolasina in this case, and I believe that one that was flashed up there and made to look like an abuse case with the 37-250, I believe it was Mr. Bolasina on that, as I'm thinking back. And that was the $16 million case, I believe. I'm curious to look at it. But it's the point that I'm making with that is that Bolasina, Ashbaugh, Meyer are all attorneys that know what they're doing, and if given the opportunity, the defense plan that Mike Bolasina gave to the insurance company was comprehensive. He wanted to defend the case. They didn't approve it. So is there? And then when he's protecting his insurance, that's what he's supposed to do.
And then I'll move on from this line of questioning. Is there anything that you've seen that suggests that the plaintiffs, the attorneys conduct themselves in any way that violates the process for obtaining a consent judgment settlement?
No, this is very, when an insurance company acts in I'll use the word arrogant, but in a manner like this, this is what a good, competent plaintiff's attorney should do.
And then it's up to the court for these factors to decide whether the number is reasonable.
Correct.
Okay. I want to go through some documents that were discussed. Just, I know, Your Honor, you have a large record in front of you, but I'm going to try to move through these quickly. May I approach?
Yes.
And may I publish, Your Honor?
Yes.
Try to do this. You turned to 116. Yeah, and turn to the second. Let's look at this. I want to just like a little complicated about it. I just wanna- Okay, so for the record, this is a February 28th, 2012 email from Mike Lasuna to Jacqueline Holman. Do you understand who Ms. Holman is?
Better remind me,
Yeah, it's the Philadelphia adjuster.
yes, I actually,
And do you recall whether this is shortly after the long status letter that Mr. Lasuna wrote there?
I believe it was.
And what's the purpose of that I mean, that defense, name wrong for a letter that spells out the case and the risks and all that? Would the status letter?
Oh, the status letter. That was basically to let them know what's, I mean, that's got the litigation plan and
Okay.
proposed budget, and basically to tell them what's he needs to do in the case.
Let's look at the actual budget. Have you seen this document before?
I have, and I'm looking at it now.
And what do you understand is, well, let me ask you, is this budget covering it?
Sorry, I got it. I believe it is.
And does it have a total for projected defense costs down at the stage for discovery? Or look at just, let me move this along. Look at the final, the last page.
Yeah, it's 242, 175.
Do you understand that Mr. Balsina was asking for $242,000 in order to conduct the discovery he needed?
Correct. He was saying that's what the cost would be.
Do you know whether he was ever paid this amount?
Object to the,
I don't know how
Hang on,
much.
there's an objection. The question is, do you know? So I'll overrule that objection. Let the witness answer if he knows.
I don't know.
Okay. You do know from the record that none of the depositions were taken, right?
Correct.
Okay. I want to just may I approach on?
Yes.
You, when counsel was asking you questions about the 8-day period, you made a comment that you think the negotiation, and he asked you questions about he asked you questions about this 8-day period and yesterday, and whether it was hard bargain or hard ball, take it or leave it type of offer. You testified that you thought there was more to it than Mr. Cochran sending the covenant judgments and then saying it's trial or not, right?
My recollection from looking at the file was that negotiations had started about a year before, and that there was back and forth substantially, that they were trying to get the mediation regarding the coverage issue. They were trying to get parties together, and Balsina was asking, what can I do to get this insurance company going? Then there was back and forth, and they hired Ashbaugh and Meyer. Then there were requests to, okay, we're going to have to, there's a request at the 4.95 as was pointed out. And then there was ultimately review by Ashbaugh, Meyer, advice to Philadelphia to get it settled. Philadelphia filed a deck action instead. not a deck, actually, the interpleader, and didn't allow the defense. Discovery cutoff passed. And at that point, there was a final statement that, look, we're going to go to trial. You have a choice. You could agree to these. They came back and said, to the consent or covenant judgments, they came back and said, well, we'd like you to include covenants not to execute. That was said, is finally agreed to. And then the covenants were signed.
I want to look very quickly, because we need to get this, very quickly at some documents, but the $1 million, the ruling of the deck action by Judge Layton, is it your understanding as to whether the issue of coverage is resolved even today?
I thought it's on appeal, and so I'm going to say that the answer, or it's stayed, I guess. So my answer to that question is it's not resolved, and there's more to come on that. So
And plaintiff has a right to appeal
correct.
Deck action verdict, correct?
Correct.
Take a look at Exhibit 74, and Your Honor, may I publish?
Yes.
And this is an October 21st letter from Mr. Cochran to Mr. Bolasina. And after the thank you in the first paragraph, almost the first sentence, I still need. Can you read that paragraph, please?
Yes.
Your Honor, I'm going to object. This seems to go beyond my cross-examination.
Let me look at it. You don't need to, it's overruled.
Does this appear, what's Mr. Cochran doing right here?
He's trying to figure out what coverage is available and to cover the claims. And he's indicating to Mike Bolasina, who's the defense attorney, that his belief as to the available coverage. He's also pointing out that the sexual abuse is extreme, has harmed a number of young, vulnerable children. And it's important to get the coverage questions answered right away.
Okay.
So that it can be evaluated.
Yeah, let's look at the date. Tell us what the date is.
October 21.
I'm going to represent you that
2011.
The trial date was October 2012 for the first group. Does it appear that Mr. Cochran is being proactive to try to resolve the coverage issue?
This is the point I was making. That the answer to that is yes, and that it started about a year before the trials. That's why I was objecting to the little capsule that I was presented with during the cross.
Does this look like a take it or leave it proposition on coverage?
No, it looks to me like they're trying to figure things out.
And what does he want to do in the second paragraph, Mr. Conlon?
He wants to take the 30B6 deposition and I need to post it. Right. He wanted, I mean, you're trying to determine coverage position. So
we have a dispute over coverage. I'm sorry.
We're trying to determine.
You're trying to determine coverage. And so the 30B6 deposition would be to help figure out coverage. And then also this, a deposition of somebody at Philadelphia Indemnity regarding coverage.
And then take a look at the last paragraph. It reads, you may know already that I've tangled with Philadelphia Indemnity over coverage issues before, and it references a case, but I want to draw your attention to the last sentence on the next page. Not the last full sentence. Its approach in the Oregon litigation of the BC TCI case seemed to end both poorly and inefficiently. So I'm hoping that it will agree to move to a more sensible solution in this litigation. What does it appear that Mr. Cochran wants to do?
Objection, Your Honor. This has nothing to do with this case. This is in another case.
Let me rephrase it. I'm sorry.
The objection is sustained, but I'll allow another question, Mr. Fowl.
Thank you. Does it appear that a year before trial, Mr. Cochran is looking for a sensible solution for all parties?
Yes,
Right. And is that something a plaintiff's lawyer or any lawyer should want to do?
yes.
Right. Can you turn to exhibit 75, please? And may I publish, Your Honor?
Yes.
Thank you. The date is December 1st, 2011, and let me just ask you this. Does this appear to be a policy limits demand based on at least Mr. Cochran's understanding of what he believes the coverage is, still believes the coverage is?
Yes.
Does that appear to be a proactive solution to resolving this case?
Yes.
Can you turn, do you have 66 in front of you, Mr. Conley?
I think I do.
You do have 66?
I do. I do.
Let me represent to you, Mr. Conley, that 66 is the letter that looks like it predated by a week, the request for discovery budget. May I publish, Your Honor?
Yes.
Yeah, I just want to look at this closely. Well, let me just ask you, look at the last page, please. It's base stamp 4442. Find it on this. Second to last paragraph, plaintiff's counsel has revealed that he believes the insurance company's coverage limits for OELC are $4 million, and he's willing to settle. And while he disagrees with the assessment, does this appear to show that the insurance company knew that there was a coverage dispute at this point?
Correct, absolutely.
And it is also shown that Mr. Bolasina forwarded the plaintiff's, I won't say timely because it's 2 months later, but forwarded the policy limits demand to Philadelphia.
Yes.
Do you know whether that 30B6 deposition ever occurred?
I thought I saw something that it had been quashed by Philadelphia.
Let's take a look. Can you turn to exhibit 70, please? May I publish, Your Honor?
Yes.
Let me represent to you that this is an email exchange between Mr. Cochran, plaintiff's lawyer, Mr. Bolasina, and defense lawyer. And this is one of those that you read from the bottom up.
Then you do it a different way.
Very.
Yeah, please.
Well, let me read it to you, well, if that's okay with Your Honor.
Yes.
On March 15th, 2012, Gerald Cochran asked if he's wanted to make sure you're set for a status conference. And then if you read, there's an email exchange, exchanging pleasantries. On March 25th, oh, there we go. On March 25th, Mr. Cochran writes to Mr. Bolasina, for the record, Your Honor, Mike, you and I had discussed setting up a mediation to address coverage issues with the Philadelphia indemnity sexual abuse endorsement. It seems like it makes sense to do that earlier rather than later, so everyone can understand the costs/benefits to hiring legions of experts in this case.
Right.
Does it appear, at least this stage, that Mr. Cochran was also trying to mediate the coverage issues.
Correct.
And do you understand who they wanted to mediate the coverage issues with?
Somewhere I think I saw Tom Harris's name back in the records. Tom Harris is a mediator that does coverage issues and has written on insurance coverage.
I guess same theme, but we're now, 4 months after the first letter. Does Mr. Cochran continue to appear proactive in trying to resolve the case earlier?
Yes.
Let me ask you, from your 35 to your 40 years of experience as a trial lawyer, is there a point at which, as a plaintiff's lawyer, you say, we're ready for trial, and this is the value, I think, we're going to go to trial?
Yes.
Is there an end to every negotiation?
Yeah.
I think this is what I'm getting
The
at.
answer is yes, and particularly when you're approaching trial, you have to make a decision. Am I going to trial? I mean, there's three things you can do. One, I'm going to trial. I'm going to try to settle it, or maybe I'll hold open the settlement during trial. But there's problems with doing that. It distracts. So, it's the answer to your question is yes. You need to end the negotiation and go forward.
And is it important for a good plaintiff's lawyer at some point to let the insurance company, the defendants, know that they're going to trial in an effort to resolve cases?
You do, and I think here it was particularly important because it said, we're going. So you've got to take the steps that are you're going to take.
And again, I'll read for your honor, since we're having technical difficulties. That the next day, Mr. Bolasina emails and says, I just got back from vacation. I will pitch it to Philadelphia as soon as I dig out. What was he pitching to Philadelphia?
Wait, strike that. Say that again.
Sure. I'm reading up the email chain.
Oh, I see.
I will pitch it to Philadelphia as soon as I dig out.
He's saying the mediation, he will ask Philadelphia Insurance Company about the mediation of the coverage issue.
So it appears at this point that Mr. Cochran has made a policy limits demand, has requested person most knowledgeable deposition on coverage, and is asking to mediate.
All of the above, correct.
Take a look at Exhibit 71, please. May I publish?
Yes.
Or may I attempt to publish? Publish? Yeah, we're having trouble with the emails, Your Honor. I apologize. This one, can you see it or should I read it, Your Honor?
I can see it.
Okay. Well, I'm going to read it. Mr. Bolstina writes to Daryl on May 18th, so another 3 months have gone by. I spoke to the Philadelphia company claims adjuster. She is going to recommend a mediation on coverage issues and get coverage counsel from Soha and Lang involved to see if we can make progress on this issue. Does it appear, we're now, I think, 6 months since the first letter from Mr. Cochran, that he continues to be proactive in trying to resolve this case?
Yes, it does.
And then if you look up, Daryl responds, sounds good, Mike. On topic, we are setting up a 30B6 step for Philadelphia indemnity, and we need available dates from you and your folks. I want to get it done soon, so let me know. I'd like to do it on a Friday. And presumably, are we still moving towards trial?
Correct. This is May of 2012.
And does a good plaintiff's lawyer ever stop preparing for trial in the hopes that maybe something settles?
The answer is that absolutely not. I mean, it's, if you play for settlement, you're either going to get a lousy settlement, or if you prepare a case for trial, you're going to get your best.
76, please.
Hang on, I want to make sure that,
I'm sorry.
it's okay. The answer from the witness is absolutely not. If you play for settlement, you're either going to get a lousy settlement, or if you prepare a case for trial, you're going to get
your best result for your client.
Do you have 76 in front of you? May I publish, Your Honor?
Yes.
Let me represent to you that this is a July 19th, 2012 letter from Mr. Cochran and Mr. Cena. And he makes another policy limits demand, but adds, clarifies that it applies to OELC and the executive director, Steve Olson, and the program director, correct?
Correct.
All right, so, turn to the second page, please, and the paragraph that begins, in addition. And I want to focus your attention, Mr. Conley, down here because we've heard the facts of the case. And it reads, I'm referring, Your Honor, to the sentence that says, based on years of settlements and jury verdicts in sexual abuse cases, I am certainly in the likely verdict range for the cumulative total of the plaintiff's claims greatly exceeds $15 million. Counsel on cross-examination was somehow suggesting that the value of the case miraculously went from $4 million and 3.95 to 25. Does it appear that Mr. Cochran had, well, what does it say about what Mr. Cochran's belief in the value of the case has always been?
Well, that they're well above 15 million there, and I think in the back and forth, I explained this with counsel, but the value of the case is much greater. It bears no relation to the insurance coverage.
Well, and I'm showing you this to establish, and I think it's clear that Mr. Cochran did not pull numbers out of the air, correct?
Correct.
Okay, and to further support, and who's he writing to here? Who's he trying to convince?
Well, at this point, he's talking to Mr. Bolasina, and I think he's trying to convince both Mr. Bolasina and probably assuming that Mr. Bolasina is going to be talking to Philadelphia as well.
Would you agree with me that this letter demonstrates that both defense counsel and Philadelphia Indemnity knew what the plaintiffs felt about the value of these 6 cases?
Yes, yes.
He also references the $8 million verdict. You understand that to be the SO verdict.
Right, the 60-year-old gentleman.
And would you agree with me that in a negotiation, that a very powerful comp or comparable would be a verdict you got a few months earlier?
Yes.
Okay. And would you also agree with me that if your plaintiff's lawyer looking at values, that it would be hard to suggest less money for a value in a case you think is not as strong? That was very cool. I'm sorry, do you understand it though?
Yeah, I think the answer is yes, but maybe repeat it so I'm not
Sure.
making
Would
a
you agree with
mistake
me that
here.
it's reasonable for a plaintiff lawyer not to demand less on a case that he or she believes is stronger than a case in which they've just reached
Correct, sorry.
Could you turn to exhibit 72, please?
72.
We're going to break for lunch. It's 11:55. Court's in recess until 1:30.
Thank you, Your Honor.
Thank you.
Please rise.
Aye.
Court is now in recess. Here's your coffee and I just have some of those.
No, I'll take, nah, maybe I'll take the Germans. Before anybody else plucks it out of. Yeah.
I'll try and bring that.
Can I stay in here?
Sure.
Okay.
Yeah, I just locked the door.
I understand.
You go out, you can't get back
Right.
in. If you need to let somebody in, just make sure.
Yeah. Hey, Laura, you can just nap and all here.
No. Saying, it might be good.
I would like to stay in for a little bit. I'll come out in a second. That's my First tech failure in the history of our firm.
Truly, yeah. And it was weird because it was.
It's just the emails. The letters,
It's the color, the way that they're colored. Back then, the hardware. Interesting.
sorry, Jack.
What's that?
Wanted to get you out there.
Please rise. Court is now in session.
Be seated, please. Thank you. Mr. Farr, you may continue.
Thank you, Your Honor.
You ready, Mr. Conlon?
Yes, I am.
Before the noon break, we were looking at Exhibit 67. You still, may I approach on it?
Yes. If you want to put, it's okay if you want to use.
Oh,
the bench.
okay.
You're getting spread out.
Okay, all right,
I've got
thank
a
you,
big
honey.
bench. Yeah, sure.
I misspoke. We were looking at 76, not 60.
Okay, I think that's,
May I publish, Your Honor?
Yes.
And to refresh your recollection, Mr. Conley, this was the second policy limit plan.
correct,
But included the individual.
correct.
I want to turn your attention to the last paragraph, really the last sentence.
Okay,
Yeah. And if I may, Your Honor, read to the record, Mr. Cochran writes, "We will also then open up negotiations with your clients, OELC, Mr. Olson, and Ms. Hoisdall for a consent judgment, covenants not to execute, and assignments of claims against Philadelphia Indemnity Insurance Company. We look forward to hearing from you." What does this tell you about the insurance company's knowledge of what Mr. Cochran's intentions are?
well, it's huge. I mean, what it does is it tells, I think the question was asked on cross, when was the first time they heard about this and so forth. And the point that's clear in this letter is that it's July 2012, the issue is being discussed and actually placed into correspondence.
Your Honor, I'm going to object. There's no indication that Philadelphia, that this is addressed to Philadelphia or that Philadelphia saw this.
The court will, the document is admitted, and the parties are allowed to argue what the implications of this document is, period.
Thank you, Your Honor. So this is, well, the question, we know that the previous policy limits demand was forwarded, correct?
Was what?
Was forwarded to.
Correct.
And this process of determining what coverage is and making these demands, it started in October, so about 6 months before this point, right?
Right.
And we are now, what, 4 months away from trial?
Correct.
Let's, if you could turn in the book to Exhibit 78, Mr. Conley, and Your Honor, may I publish?
Yes.
It's 72. Your Honor, this book is 72.
Thank you.
Your Honor, this is a deposition taken in the other case. I'm going to object to this.
Your Honor, I misspoke. It's, so everybody's clear, I'm turning the witness's attention to what I believe is 72. Is that a series of emails?
It's a series of emails, first one dated July 20th, 2012.
May I publish, Your Honor?
Yes.
Again, Mr. Conley, we read from bottom to top. It is an email from Daryl Cochran, who writes to Mike Bocina. Mike, I wanted to make sure somebody over at Philadelphia Indemnity let me know that the motion for protective order was granted, so the debt is off on Monday. What's your understanding of what Cochran and Bocina are talking about? Mr. Cochran.
Well, I believe that was the deposition on the of the Philadelphia Indemnity individual, and it's a courtesy email by Daryl Cochran over to Mike Balacina, just making sure that letting him know that the dep is off, so he doesn't. I think it was down in Oregon. I'm not sure, but so he doesn't travel to a dep that's not on.
Would a 30B6 deposition on coverage have, what's your opinion on whether that would have assisted the parties in trying to resolve this case?
Well, I think it would greatly assist. I mean, for certain, it would give there'd be knowledge of the differing positions. And then as far as negotiations and so forth, that would be extremely helpful.
And do you know whether Philadelphia moved to quash that deposition?
That was my understanding. I think I mentioned that a couple of times, and the fact that a protective order was granted would support that.
Let's move up the string. And Mike Balacina writes back, thanks for the info. I had not heard. And then he refers to the policy limits demand, which is, if you mean the recent demand, no. If you mean the $4 million demand from a while ago, yes. And it appears they're talking about the July 19th policy limits demand that we looked at in the past exhibit. Would you agree?
Correct.
Okay, and then he says Rosner agrees that a mediation with Harris is a good idea. Is this where you recall that Harris was
Tom? Tom Harris is an insurance. He's a mediator with WAMS, and he's an insurance expert.
Do you understand Rosner to be Mr. Rosner that's sitting behind me?
I believe so.
Okay. So do you know what his role, why he's appearing in July on this case?
Well, I'm not. I think that. I mean, I guess my thought would be that there's thought that they're going to try to argue coverage and fight coverage and keep it as low as possible.
Okay. And Rosner agrees that a mediation with Harris is a good idea. And then agrees that a mediation with Harris is a good idea. And then Mr. Balacina states, I am not sure how to get Philly to move forward on this suggestion except to take steps towards scheduling this. What's your understanding of whether a mediation had occurred at this point?
Well, I don't think a mediation had occurred, and they were trying to get it scheduled. And this is one of those emails that I'm talking about where Balacina is talking about the fact he can't get Philadelphia moving forward, can't get Philadelphia to do things that they're very recalcitrant about.
And then
their job.
Up above, Mr. Cochran suggests that we resend the policy limits demand, correct?
Correct.
Let's turn to Exhibit 68, please. May I publish, Your Honor?
Yes.
If you look at again, we'll read from the bottom, on August 1st, 2012 at 1:59, Balacina is writing to Ms. Holman, the Philadelphia Indemnity Adjuster, copying Mr. Rosner, and He says, Jackie and Paul, I have attached a letter received today from Daryl Cochran. It is in response to my letter sent Monday rejecting the policy limits demand, in part because of a disagreement over the policy limits, and in part because of the existence of an additional potential claimant. Counsel for Philadelphia objected to the question a few minutes ago about whether they received the policy limits demand. Does this suggest, well, what does this suggest to you about whether they received it or not, or whether they knew about it?
Well, they clearly did.
Then, this is curious, take a look at the next, Ms. Coleman writes Mike Bolasina and says, thank you for forwarding Mr. Cochran's letter. Could you please send me a copy of your 7/30/12 letter to Mr. Cochran? And then she says, it does not seem to me that Mr. Cochran's letter requires a response. What do you make of that?
That I don't quite understand. It's not typical insurance company reaction. It's normally you would think that there should be a response, and I don't understand what they're basically doing is telling him you ignore it.
Okay. Let's read above for some more context.
Okay.
And then Mike Bolasina writes back when she says, I don't think your letter requires a response. And Mike Bolasina writes back to the insurance company and says, in closing, Cochran invites a discussion on the issues raised. What does this tell you about the plaintiff's goal to resolve coverage at this point in time, which is August?
Again, there's continued efforts by the plaintiffs to negotiate to resolve these issues, and those are being ignored.
Okay. Then it says Paul, presumably Rosner, is in a better position from a knowledge base to discuss coverage limits, interpleader actions, and other issues raised. But if I can move this down the right path in some way, I can. What does it appear that Mr. Bolasina is trying to do?
He is trying to get discussions going. He's trying to help his insureds. He's trying to get the insurance company moving, and paying attention to the potential of resolving and working on resolving the case and indemnifying their insureds.
We are now 2.5 months away from trial, correct?
Correct.
And we still don't have, after almost a year of trying, we still don't have resolution on the coverage.
Correct.
And then we talked about this a little bit later, but perhaps this document will help assist the court. He says, note, as referenced in his letter, Cochran did get an $8 million verdict last month in a sex abuse case against the Catholic order. The local archdiocese was paying on average about a $500,000 civil claim before, but I suspect that figure will now increase. This was about 8 times what I thought the case was likely, where it's based on what I knew about it. And again, you understand this is the SO case.
Correct.
What is the significance in terms of Mr. Bolasina's sharing the $8 million verdict with Philadelphia 2.5 months before trial and about a month before the consent judgment?
It's more effort to get them to pay attention to the case and basically telling them that the case has potential to be quite large. That there had just been a large verdict and that's, from the same attorney, and that's what was heading down the pike.
And do you have Exhibit 82? May I approach your number?
Yes.
I don't think you have it. You don't.
Okay. Can I ask what date the September 30th or the October 30th letter was, or what exhibit number?
Yeah, over the 30th letter.
I think it was the one referenced in the email.
August 30.
July 30?
Yeah, what exhibit number is that?
I'm not sure what you're talking about.
That, I think it is July 30th.
Okay.
What number?
The July 19th.
Off the record, Ray.
Thank you. It's exhibit 76 is the demand letter.
76. What I was looking for is the one that indicates that, oh, there it is, okay. Okay, I referencing the discussion about the consent judgments and so forth coming down the pike.
On the record, Ray.
Mr. Conley, you inquired about what letter was referencing the consent.
Right, that we had discussed earlier, the letter referencing that there was consent judgments and coming down the pike, and that is exhibit 76. So I just was checking that because of one of the other questions you asked.
Okay. Let me ask you to turn to exhibit 82.
Okay.
I'll take that. Sure. May I publish your words?
Yes.
Let me represent to you that this is the insurance action filed in the Western District at Tacoma with Judge Layton.
Correct.
And I'd ask you to turn to the date that this was filed.
August 24th of 2012.
And what's your understanding of when the first trial date was?
I know the discovery cutoff ended August 14th, and I was thinking the first trial was, I'm not sure I remember exactly, but it seems to me it was October. I'm thinking back to the conversation with Judge McPhee.
Well, let me ask you, if it was October, let me ask you the question. Is this declaratory judgment action was not resolved as of the first trial date, correct?
No, it would not be resolved that quickly.
And this is something that could have been filed much earlier.
Could have and should have been.
Would have and should have.
Correct.
And whose action is this to file?
Well, a deck action.
Yeah.
Generally, an insurance company would do that if there's a question of, in their minds, of coverage, and it should be done early so it can be resolved.
Does plaintiff have any obligation to wait when an insurance company has acted in this manner? Does the plaintiff's lawyer have an obligation to wait?
No,
Until they resolve their own coverage issues?
not at all. No.
And strategically, would a plaintiff's lawyer do that?
It would be, there's no reason that the plaintiff should be waiting on the insurance company. The insurance company has a contractual obligation to indemnify. The plaintiff doesn't wait for the insurance company to do their job. The plaintiff moves his clients forward to a trial.
In other words, you don't have an opinion as to whether plaintiffs did anything wrong by aggressively pursuing. Well, do you have an opinion as to whether plaintiffs did anything wrong by aggressively?
I do have an opinion, and there's.
By aggressively pursuing their option.
Please. Last thing I have is, well, you have an opinion as to
Whether the plaintiffs did anything wrong by aggressively pursuing their litigation options.
And my answer is, I do have an opinion, and my answer is that no, they not only did they do nothing wrong, that we're in an adversary system. Our job, a plaintiff's job, is to represent his clients and to move their case forward. His job is not to wait on an insurance company that's trying to reduce its exposure.
I want to show you one of the defense exhibits. Thanks.
Started by the one.
Right. I have a moment, Your Honor. Okay. Approach.
Yes.
Turn your attention to Defense Exhibit 560. No. And Your Honor, I can't publish this because it's not our exhibit. We haven't downloaded it, but I want to ask Mr. Conley to read it, and I have some questions for him.
Your Honor, while we're doing that, just for housekeeping purposes, there's a question as to whether or not all of these exhibits that have been submitted to the court, because this is a reasonableness hearing context, whether they're all admitted for purposes of your review of this whole matter. We've been referring to publishing. We're not trying to get documents admitted as authentic or unauthentic or relevant or any of that. We're assuming that all the documents that have been submitted to the court by the parties are deemed admitted and available for the court's consideration.
Mr. Cochran?
I disagree.
Granted, so be it. So ordered.
And Your Honor, I think I understand that I'm asking your permission to put it up there.
Yes, granted.
Laying a foundation. Have you had a chance to read Defense Exhibit 560?
I believe so, yes.
And Your Honor, I think we do have that downloaded, so with your permission, I'd like to publish.
Yes.
What is Defense Exhibit 60?
It's a series of emails that involves Paul Meyer, who was representing, I believe, the Olympia Early Learning Center, and Daryl Cochran representing the plaintiffs, and John Masterson, who I believe may be a board member of the Olympia Early Learning Center.
And Meyer, who's the OELC lawyer, is writing to who you believe are board members. And he is sharing an email exchange between himself and Mr. Cochran, and is talking about the documents that they're discussing the consent judgment, right?
Correct.
And I'm going to ask Mr. Cochran to scroll all the way down so we can read it in order. And so Mr. Cochran says, I'm still in, do you have the first exchange?
Yeah.
You do. Oh, where it says Mr. Cochran? So Paul Meyer writes to Mr. Cochran and says, the Learning Center does have some assets that it would like to protect. That is the reason that it desires having the benefit of a covenant not to execute if it is going to sign a settlement agreement that includes a stipulated judgment. What is the difference between a stipulated judgment and a covenant not to execute?
Well, the covenant not to execute says that you will not execute against the assets of the person that's entering into the agreement. The stipulated judgment is simply a judgment that both parties agree to. Sometimes they'll have a covenant not to execute, sometimes they won't.
And Mr. Cochran writes back, I can work with you to protect their assets. I'll first need to understand, so let's talk soon. And then he verifies that he does not represent ND, correct?
Correct. I think the below email had asked if he did represent ND, and he clarified that he does not. The what this is basically it's further negotiations, and it's Mr. Cochran stating that I understand your clients want to protect their assets. Mr. Meyer is working for their benefit to protect their assets, and he's saying, I'll work with you to protect their assets.
Let's scroll down a little further.
Okay.
To the 453, September 13th, right here, yeah. And it says, have you concluded your trial? The assets that the Learning Center desires to protect are about $150,000. Do you recall the line of questioning about hard bargaining and take it or leave it?
Correct.
Yesterday? What does this tell you about whether the parties are negotiating over the terms of the stipulated covenant judgment?
It tells me that they are negotiating over the terms. It's not a take it or leave it without negotiation.
And okay, could you turn final? If you have, I'd like you to turn to defense 595. I think it's in this binder.
Okay. I think I've got it.
Is it in August 31st, 2012 email from Daryl Cochran to William Ashbaugh?
Correct.
All right. Your Honor, may I publish?
Yes.
Why don't you take a moment to read that? What does this document tell you about the state of the situation as of August 31st, 2012?
Well, what's going on is that William Ashbaugh is doing the same thing as Paul Meyer is. He's trying to protect his clients. And he's telling Daryl, first of all, that they're reviewing the settlement agreements, and we'll get back to them. Only the lawsuits against OELC are referenced in the recitals. Did you mean to reference the lawsuits against Steve Olson as well? And at that point, Ashbaugh is representing Olson. And then Daryl Cochran says, yes, that was an oversight on my part. Thank you for confirming. And then states that I think that there had been question by Mr. Bolasina as to whether the Philadelphia indemnity deck action, which had any impact on anything. And he said, no, it doesn't. and sets forth the reasons that it didn't, and that was because of the fact that Philadelphia was acting in its own benefit, not for its insured's benefit, and had been for a period of time.
So at this point, we are a month and a half away from trial. What are plaintiff's reasonable options here?
Well, the plaintiff's options are to resolve it and go to, with the judgments, go to trial and get a verdict, a major verdict, and against the defendant. So really, those are the two options at that point. This is August 31st. That's it.
And is Mr. Cochran telling Mr. Ashbow what he thinks the best approach is and what he intends to do?
He's telling him that because of the fact that Philadelphia is working in its own benefit, failed to provide a good faith defense, we must secure judgments against the defendants. We can do that by proceeding to trial and securing jury verdicts, or they can do the covenant judgments and covenants not to execute.
And what are the defendant's options at this point?
Defendant's options are to go to trial, in which case they don't have the consent judgment and the covenants not to execute, or they can enter into the consent judgments and covenants not to execute. The way they protect their assets is by entering into those covenants.
Would you agree with me that the defendants have very limited options at this point?
Yes.
And from the series of documents we've gone through over the last 45 minutes, starting in October 2021, through this email, do you see any evidence of collusion?
No.
And do you see anything in terms of the negotiations based on bad faith law in this state that is inappropriate on the part of the plaintiff's attorney?
No.
And in fact, does it appear that the plaintiff's lawyers are willing to work with the defendants to save their assets?
The answer is yes, and the defense attorneys are working on behalf of the defendants to protect their assets.
And at this point, we have 4 or 5 lawyers in the mix trying to resolve this, correct?
Correct.
Let me take some of those notebooks. Wait for you to go through it.
Drown.
I want to change gears a little bit, Mr. Conley, and just clarify some things from cross-examination yesterday. Can you turn to plaintiff's 23, please?
Yes.
Let me know when you're there.
I'm there.
Okay, this is the psychosexual evaluation treatment plan. We looked at this yesterday. We looked at Mr. Logan's. This is Sue Batson's psychosexual evaluation and treatment plan. Do you recall seeing this before?
Yes.
All right. I want to turn your attention to page 2 and the paragraph that begins when S.
Page 2 and when S.
Or you can look at the screen if that's easier.
Oh, that is easier.
And you were asked, counsel, when questioned, you kept referring to 30 to 50 incidents of abuse. Do you remember that?
Yes.
I want to look at the next paragraph, and detective called, conducted a forensic interview with the victim, and told him that he had spoken with Eli. And Detective Call also asked the victim how many times Eli had touched his private part. And the child, of course, says a bunch, and then eventually clarifies that it's over 50 times. What does that tell you about your opinion as to how many times this child was abused?
Tells me it was going on a lot, all the time, over a period of time. It's, Eli Tabor did not count the number of times. He didn't document it. The most likely question by the examiner is something like, did it happen more than once? Yes. Did it happen more than 10 times? Did it happen more than 50 times? That type of thing. And so what we're learning here is that it had happened a lot.
Does it also indicate that the child told Eli to stop?
If
you look at the next sentence down.
Yes.
And what did Eli do when the child told him to stop?
He wouldn't stop, and that made, I assume it's saying it made S.A. mad.
And then if you look down to the next paragraph, it looks like the police officer, in trying to understand what happened to the child, interviewed both perpetrator and victim, right?
Right.
Because it says the client's version of the offense, client being Eli. He admits to it, and then he said, although he said it started with masturbation and escalated to Eli sucking S.A.'s penis 10 to 30 times. He would also lick his butt. Eli said on 2 occasions that S sucked his penis. But what do you make of this admission as it relates to your opinion of damages?
Well, it's significant. If you go up to that upper paragraph, what you're seeing is very typical in sex abuse victims, and that's that the victim will say, how many times did it happen? And they'll say, oh, just one time initially, and then it expands. But you've got down below when they talked about Eli, and he's saying that it happened many times. And that's and then the other thing that's very significant is when somebody is overridden and they're told, they say stop, and then somebody doesn't stop. That is a major factor on damages.
Let's turn to the next exhibit and go to it's 24.
Okay. Well, I was going to make one more point on that, and that's that the other thing that was significant during that interview is that he wasn't saying it. He was trying to protect Eli. So S.A. at that point, he was afraid Eli would get into trouble. So these interviews are not, they're to be taken with an understanding of what they are. They're sexual abuse interviews. They're not, it's not, what we know from this is there was a lot of abuse that was going on. There were indicia of it throughout the time that he was in the center, just like with the other kids. And when it finally was revealed, it was many times.
Do you have an opinion as to whether it was likely he was abused in excess of 50 times given?
I feel like it's almost certain. Yeah, and given the fact that there's the napping, the kissing, the everything that's going on for the 2 years before this.
And I'd like to turn your attention to the next exhibit. It's 24. But before I do that, I want to, well, do you recall being asked as to whether anyone at OELC knew that Tabor was a diagnosed pedophile between 2008 and his arrest in 2011?
I remember being asked that, yes.
Yeah, and is it common in your cases, Mr. Conley, your negligence cases against institutions involving child sex abuse, to have evidence that the perpetrator was a diagnosed pedophile under DS-95?
No, I mean, you never have that.
Why do you chuckle?
Well, the reason I laugh about that is for someone to say, yeah, he's a diagnosed pedophile, and then stays in the learning center working with kids for 2 years that never happens. And typically what you see, you don't see as much notice as you do in this case, but you see what I've been calling indicia that leads people to be concerned. And then usually there's a reaction to that concerning. A lot of cases you have 1 or 2 incidents of notice. This one, I wrote little red flags on it, and you've got probably about 20 to 25.
And this goes to the issue of plaintiff's liability case.
Correct.
Just so we're clear, there's nothing in Washington negligence law that suggests you need a DSM-5 diagnosis to be held responsible for failing to take action, correct?
No.
Okay. May I publish 24, Your Honor?
Yes.
And I'm going to look at these quickly, Mr. Conley. But 24 is plaintiff Lisa Steele. You'll recall that that's JT's mother.
Yes.
Her amended answer to defendant's written discovery. And you have that in front of you?
I do.
Will you turn to interrogatory response number 10?
Yes.
And I'd like you just to read that to yourself, and I have some questions about it. I know when you're done.
Oh, I'm done.
Okay. What does this interrogatory response detail?
Well, it details Lisa Steele's going to OELC and telling them of her concerns with regard to Eli Tabor. It started out she was concerned because he wasn't watching the kids, and she noticed that he was starting to he wasn't acting like a teacher or supervisor, monitor. He wasn't acting like an employee. He was acting like a friend to the kids. And then I think it goes on and he's, I wrote these on my timeline, but he's in the sunflower room. He's acting out his sexuality on the children, which is a major red flag. But he's at that point stroking them and stroking the legs, hugging, touching. Those are, particularly when a parent sees those and brings them to the attention, they're major red flags.
Would you agree that she complained at least 4 times to administration about
Yeah.
her child was abused?
Yes.
And would you also agree that that the concerns, at least she said she expressed, she made it very clear before her daughter was abused that she was concerned about how Tabor was behaving sexually to the children?
Correct.
And stroking young children's legs is highly inappropriate, is it not?
Correct.
I'd like you to turn to exhibit 66, if you will.
66?
66.
I don't think I have that one, but, or maybe I do. No.
Can I publish, Your Honor?
Yes.
I referred earlier to a February 21st letter from Policina to Philadelphia. I call it a status letter, but letter we're really telling her about the case is correct.
Correct.
You turn to page 44, base stamp 4434. And look at the paragraph that begins, Tabor had performance and disciplinary issues throughout his employment.
4434. Okay.
The second page of the letter.
Okay.
Counsel on cross-examination asked you questions about notice evidence. And first of all, Exhibit 23, we just looked at the complaints from Lisa Steele. That is notice evidence, correct?
Correct, and that's early.
And that evidence would have gone to the jury.
Correct.
And take a look at what Mr. Policina is writing Philadelphia indemnity adjuster about. And she's referencing disciplinary issues. He was written up approximately 10 times for failing or refusing to follow rules, such as remaining in his assigned classroom, tardiness, unexcused absence, refusal to follow direction, losing his temper, and the like, and his performance evaluations demonstrated that. And then he said there's one disciplinary matter that is of particular concern. And he tells Philadelphia that during a CPS investigation, an employee or former employee provided CPS with an unsigned 2009 reprimand for violating policy and lying down with one of Tabor's victims. The memo is purportedly authored by the program director and the West Side site director. And while she denies she knew about it, it came up in the course of the CPS investigation.
Correct.
Does this suggest that it is likely that all of this evidence was available in 2009?
All of the evidence was available, and I think I mentioned this yesterday, and I was asked about when they had occurred, and this is the answer. I couldn't recall the dates, but it's all available in 2009, and he's written up approximately 10 times.
There's no question that this is a big problem employee, right?
Correct.
Will you turn to the next page, please? I want to look at the paragraph that begins as part of its investigation. So CPS apparently interviewed witnesses, right?
Correct.
And what did the witnesses tell Child Protective Services?
Well,
about his relationship with SA?
and we've talked about that, but that he was obsessing and that it was an abnormal relationship with SA and that they had been reporting that to OELC, to Rose Horkdahl.
All right, let's look at the next paragraph very quickly. And it looks like it said the CPS investigation focused on the director herself, right? The administrator.
Right there, it did, correct.
And in a situation like this, would it be the administrator that would be in the best position to take action when they have a problem employee?
Well, certainly that would be one of the people.
Anyhow, Mr. Bulacina writes to Philadelphia that the CPS investigation results in 2 findings against the director, right?
Correct.
That I am not concerned about the first finding, as no harm occurred between the initial call to Ms. Horkdahl and the ultimate report to CPS. Second, Ms. Horkdahl failed to contact CPS years earlier after several teachers allegedly reported to her concerns about the relationship and after she allegedly disciplined Tabor for violating rules by lying down with this child. This finding is more problematic. Why is this finding more problematic?
Because she's a mandatory reporter, and when there's indicia or indications that a child is being abused, she has a legal duty to report that. I mean, this was the 3rd CPS investigation in the, and there's an obligation she has to make sure that they're being reported and that kids are being protected.
And Mr. Bulacina is noting the second one. I mean, is he implying that there was harm caused by her failure not to act? And that's why well, let me ask you.
Well, it's like notice evidence. I mean, she's not doing anything, and so there's further abuse that's occurring.
Turn to page 4437, please. You referenced in your cross-examination a complaint made by the cook, and I want to, on this page, turn your attention to the paragraph that begins prior to the arrest.
Yes.
And here, why don't you take a look at it? Is this the reference you're referring to about the cook?
It is, and there was also, I had another one about Sonia Riley Clifton as well. But it is, I mean, that's, I don't know, what's interesting about this to me is I had represented Ms. Clifton a number of years ago. And so, yeah, that was significant. I know her, and she had a child that was arrested. There's there's more information in the file relating to that. So,
okay.
Yeah, I'm very aware that she mentioned she thought it was grooming, that she had experience with sexual predator training, and that she talked to Eli about that. She reported it. And it's, it should have been, somebody should have paid attention. She told Beta Harris, the site director, and it's actually there's a lot that she reported. I'm in terms of speed a little bit. I'm leaving some out, but
I'm just trying to reference some of the
right.
documents.
She recognized that there was that he was exhibiting the signs of a sexual predator, and she reported that. She was told to do nothing about it. This is huge.
When she noticed that it's not the kid, it's Tabor that is crying, right?
Correct.
What do you make of that? Crying that the kid is not a Tabor.
Well, it means that, that's part of that obsessive relationship. Um, I don't know exactly why he was crying. Maybe he was ashamed. Maybe he was afraid that there was going to be a report. I don't know exactly the crying, but the point is it's part of the obsessive relationship. And I think this led to a big screaming match where both of them were actually reprimanded, and she was told not to say anything about it.
And then this paragraph also refers to a second piece of notice evidence, which is a summer intern in 2010 noticed interactions that made the intern uncomfortable, and her discomfort was shared by other employees. This is again Bolasina writing in Philadelphia. She states that she told Beta Harris, the site director, about her concerns. And what did Ms. Harris do about this?
Well, told her to do nothing. I've got, as I indicated, further information about the Sonia Riley Clifton one, and then so these are two separate ones. There's actually a number of other employees too that made reports to OELC about
I understand. We're not
problems.
going through everything. I just want
Okay.
drawing the court's attention to some of the things
Yes.
you were asked about in cross. Will you turn to page or exhibit 14, please?
Exhibit 14.
Publish, Your Honor.
Yes.
Do I have that in this book?
You should.
I think I start at 46 in
All
this
right,
book.
let me know. Got it? Let me know when you're there.
I'm there.
Publish, Your Honor.
Yes.
Okay. So let me represent to you that these are Mr. Bolasina's notes of an interview with Rose, the
Correct, Rose Hordall.
And I'm not going to go through them in detail because Mr. Bolasina will be here, but I do want to look at a couple of things that I think are important. On the first page, you see where it says left him unsupervised with ND.
Correct.
And I think this is consistent with your testimony yesterday, which is there were problems with him moving from room to room and being unsupervised.
And he would, correct, they knew about it, he was told about that, he was told not to do it, he continued to do it. It's a target-rich environment, he's given unfettered access to the kids, even after there's notice that he's behaving abnormally with them.
By the way, with regard to ND, do you recall the document that talks about Tabor claiming that the 5-year-old put his hand down his pants?
Yes.
Did you find, what do you make of that?
It's, I want to know more about that, and I didn't find enough in the file about it, but what I'd be concerned about it is I think that Tabor tried to, maybe was afraid he's going to get caught or something, and tried to go quickly and disclose and blame it on the child. Later on, it turned out he was lying, but it's the curiosity that I have on that is whether, to what extent both were interviewed, because I think this is again, it's a major red flag.
I mean, well, do you have a question about how a child could put his hand down the pants of a supervisor, how that would even happen?
I don't think it can happen. That's what bothers me about it, is that a supervisor honestly has to allow that to happen for it to happen.
Can you turn to page 12875, please?
12875.
down near the end of that, there's a paragraph that reads, Eli would leave his classroom on a regular basis. Do you see that, Mr. Conley?
I do.
I'm anticipating that we're going to hear that cases aren't worth the value that you're saying they are, because perhaps Eli wasn't in a room with the child or this sort of thing. We'll see what they do after today. But does this tell you that Eli? Well, what does this tell you about the frequency with which Eli left his classroom, his assigned classroom?
Well, he did it all the time. I mean, it's not just this note. This shows that
Objection,
Roseburg.
Your Honor, this calls for speculation.
Well, the question is designed to elicit an opinion from this witness with respect to ultimately the witness's opinion on whether the settlement is reasonable. So the court is taking all of this evidence into consideration as it relates to this witness's ultimate opinion, not to establish the truth of anything contained within any of these documents. I hope
Thank
that
you, Your
makes
Honor.
sense to the parties.
That does.
So the objection is overruled. The court will attach whatever weight it deems appropriate to this evidence.
And the important thing about this is it shows that Rose Horgdahl was well aware of it. The entire record is replete with references to Eli Tabor leaving the room, going to different rooms, one-on-one contacts, going to the bathroom, changing diapers, having unfettered access is what I've referred to it as. And there's actually reprimands and admonitions from Rose Horgdahl, but she's confiding to her attorney that she knows it. He was leaving the classroom on a recurring basis.
And when you have a employee who is a chronic violator of the rules, and right below it, it says not doing his training, presumably OELC had the ability to terminate this gentleman's employment, right?
Correct.
Well, let's take a look at the next page, 12876. It's still leaving the classroom. Eli did not like infants, went into the half pint room, 3 to 4 years old. A number of the kids he abused were in the 3 to 4 year old range, right? And then if you look down, it says May 20, and it's hard to read some of this, May 2010.
Correct.
And it says final probation. What's your understanding as to whether by May of 2010, first of all, what does final probation imply?
Well, that he was going to be fired if he didn't change his ways, but he didn't change his ways and he wasn't fired.
So let's look at the next page. We're going to go a month. It looks like Mr. Bolsina is walking through a chronology here. July 2010. Let me know when it's 12877.
Okay.
And again, it's hard to read. So July 2010 wants to terminate Eli. So in May, he's on final probation after all the problems we looked at. In July, she wants to terminate him. What's your understanding of whether he was ever terminated?
Well, he wasn't. Yeah, I mean, I've got opinions regarding this, but
At this point, does the failure to terminate this employee increase does it increase the likelihood of transfer?
correct. Correct.
Now look at the next page, 12878. Counsel asked you yesterday about whether a background check was done following the DUI arrest. Do you see where it says 9/10 or 10/10? Right there, yeah. Again, agreed. Eli arrested DUI. The new supervisor did another background check. I have an opinion as to whether a background check, now, so he's, let me rephrase that. We've gone through all the problems he has. By May, he's on final probation. By July, the director wants to terminate him. And then 2 months later, or maybe 3 months later, he's arrested for DUI. By the way, was he driving kids to appointments?
Yes, I know he was with, I think it was JJ, yeah.
So he's arrested, and they do a background check. What's a background check in your mind going to accomplish here?
Well, that's why I had mentioned on cross, I'll take your word for it. I don't think a background check of a 17-year-old really does anything. I think that I'd be surprised if anything showed up. I'm not even sure if the issues during minority, if there were any, would show up on a background check. But I don't think you'd expect anything to show up on a background, either one of these. He's because of his age, and pedophilia doesn't normally show up on background checks unless there's been an arrest.
Let's change one final area I want to clarify. Do you have 55 in Chromium?
55. I don't think I do.
Do you have that?
Yes.
All right, may I publish, Sharon?
Yes.
So I'm not going to spend a lot of time on this, Mr. Conti, because we anticipate that Dr. Conti will be here. But you were asked questions about whether Dr. Conti opined about whether the children were abused or not. Do you remember that?
Correct.
Take a look at page 2, under the paragraph sexual abuse.
Correct.
It said it's talking about AK. By winter, he was rubbing against his mother. He was displaying these sexualized behaviors. During weekends, he would wear cotton briefs, and when back in the daycare, he'd have to return to wearing diapers. And then Dr. Conti said these behaviors would generally be seen by professionals as strongly indicative of a child who has been sexually abused or in some way sexualized. What's the standard in a civil case?
Well, it's more likely than not. It's beyond, it's not the higher standard. It's more probable than that.
And I'm going to ask Dr. Conti this question. So, but would you agree with me that Dr. Conti is not saying that you can't offer opinions on whether a child is?
No, he's not saying that at all. He's actually doing the opposite.
Kind of the opposite. Let's look at 53, please. Turn to page 4. I'm sorry,
Yes.
it's another one of Dr. Conti's reports, and I'd like you to turn to page 4 and look at the third full paragraph that begins apparently, where J blank apparently. And let me reference for the court, this is the opinion as to plaintiff J.
Correct.
And I'll read for the record, J redaction apparently had a period in which he was increasingly touching and pulling on his penis and talking about drinking pee. Do you find any significance to the fact that this small child was talking about drinking pee?
Yeah, I think I'd mentioned that on a couple of them. They're talking about that. And given the fetish of Eli Tabor of peeing into diapers and masturbating, and he had a fetish regarding urination. And given that fetish, I found it striking that there's 2 or 3 of the kids mentioned, peeing. And I think one of them was drinking orange juice and talking about drinking pee. And so yes, I find it very significant.
And then Dr. Conti writes, this coupled with increased behavior and emotional problems, anger, crying, difficulty being controlled and controlling his own behavior, is consistent with behavior associated with being sexually abused.
Right.
Does it appear that Dr. Conti is opining that he can't, or Dr. Conti is stating that he can't opine on the issue of whether the child's abused or not?
No, again, it's the more likely than not standard, and he's putting his opinion forth.
That's all I have. Thank you.
Thank you.
Thank you, Mr. Conti.
Thank you.
2:42, the court is going to take its afternoon break. That's 2:42 plus 1. Court's in recess until 3:02. Yes.
Can I raise a question?
Yeah. Off the record, Ray.
I don't know if there's such thing as prisoner rights, witness rights, but prisoner rights. But I do feel like I was a little blindsided by something, and I found out 2 of them that were wrong, and I'm wondering if I could, I asked during the recess if I can get the cases that they're put up on the board, and I don't know if that's important at all, but I feel like since I was asked questions about them, I should be able to, they'd indicated they had them, and I'd like to be able to look at those.
I have agreed to do that, Your Honor.
Okay.
But there was no way I could do it while we were in trial, is what I told Mr. Conley.
But I think the witness is asking that Philadelphia's counsel provide what he has here and which he's acknowledged having here, so that Mr. Conley has the ability to evaluate it and give fair comment on it.
Well, I don't think it's an issue because we're off the record, and if we need to, I'll place this on the record. But the court placed on the record that the court was not inclined to attach much, if any, importance to that exhibit, given the fact that the witness couldn't identify what it was or authenticate it or confirm that there was any degree of accuracy. In fact, the witness said he doubted the validity of that document based on a number of different reasons. So from the court's perspective, at least at this point in the hearing, that document is of little to zero value.
Thank you.
If either or both of the parties want to explore that issue further, then I'll take up a request from the plaintiff to allow this witness an opportunity to do some investigation with respect to that document.
Thank you.
Let's go on the record, Ray. While the court was off the record, there was a request from the witness to have permission to access information that the witness believed was being held by or in possession of Philadelphia Indemnity, because the witness wanted an opportunity to review the document and have an opportunity to refresh his recollection and perhaps offer an opinion or additional evidence with respect to the contents of that document. I don't recall the exhibit number off the top of my head. And the court advised off the record and will now state on the record that the court at this point declines the request of the witness to review that document, any document, because this court placed on the record and remains of the opinion that the document itself is of little to zero value to this court, because the witness testified that he did not believe the document was accurate, did not believe that it accurately identified certain cases or accurately reflected judgments or settlements in cases that the witness was allegedly involved in. I apologize for that dangling preposition. So it's, in the court's mind, a non-issue at this point, and if either or both of the parties wish to revisit that issue by offering that document into evidence, the court will entertain argument from either or both sides with respect to the witness's request to examine the document prior to testifying regarding the contents of that document. Thank you, everyone. It's
Thank
now,
you, Your Honor.
Thank you.
it's 2:46. I got a C in math my last math class. Give me 20 minutes after 2:46. 3:06.
Thank you.
Okay. Okay.
Oh, the long thing.
Start listening to today. I feel so bad for him.
Yeah. Like I said, he just tweaked my ego.
Yes. Yeah.
Did find a lot of this.
Yeah.
Yeah, I never mentioned that, but there's so much. I know, yeah, I saw it.
I didn't know you did.
I just, yeah, no. I
No,
saw
yeah.
it. Yeah. Okay, thanks.
Yeah.
So can I ask you a question?
Oh, sure.
Is it my understanding, I just want to verify, that you have no objections to any of his exhibits and he has no objection to any of yours when they're all being admitted?
That's my understanding. Because it's a hearing, not a trial.
Right.
So this would be like a summary judgment. Yeah. That's why I wasn't laying a foundation.
Right.
Okay.
Thanks for asking.
I just want to make sure before I went and marked them all.
Yeah. So it's a weird procedure. It's a little bit like a mini trial, but it's not.
Yeah, but it feels like bench trial.
Yeah. Shoot.
I thought it was done.
But they're still going.
So there is gonna be recross.
and you just push it.
I don't know why I said we can't revise.
Probably.
Because you're behind that little barrier there. Is that-
Yeah.
Because we've been held hostage for 2 days.
Yeah, probably a good for you.
You don't like that anymore. This is a
Yeah.
unit
Oh, yes.
amplifier.
Unify switches. I think we have unify switches.
Okay. Getting the revenue access control stuff. Yeah, it's just an Apple TV with 1080p. It's not even the newest. Okay with that. Where Ethernet connection there, so it's Wi-Fi. Here, and then that's all hardwired.
Yeah, I've got a little bit of that in here.
This stuff is, these boxes here, can reach the Ethernet.
Yes.
Cool stuff. All that. Ball. Like a nuclear football. They drill a little hole in the side so the power cord can come out and it can stay closed and contained. This time I tried that. It's so hot, man. It's like,
Yeah,
it's just in that bend.
You cut out your own phones and a real tie and everything.
Yeah.
Yeah, that's pretty good.
I got the rubber that is powered by USB-C.
Yeah. That's great. So you got someone else to deliver it to you.
To not that, yeah, that. It's-
Yeah. Welcome, Harold Carr.
You look at just there.
Yeah, I did, yeah. Yeah.
We had this case,
She's over.
we had this case against the Mormons,
Oh, really?
and it was a great case. We ended up with
Years ago, 1.6.
But just the funniest part about it. She had potential toward.
Yeah.
It helpful that Judge McDermott was the trial judge, but nice guy.
It shows how important it is.
Sitting on his bench.
Yeah.
That was so much fun.
What, which one? Since you advertise for that. Software.
That's a great question. We built our own.
Yeah.
It was built by Harold Carr Senior. On FileMaker Pro. And so when I came.
How'd that go?
Harold was actually my father-in-law. So
What's that?
when I
Really
came to
important.
Fern,
I thought so. Just, please.
about 100 there. So I sat with Harold Senior in technology.
I think with the fact that this might be months away from the Moses case, we should like,
And
not writing, but he's listening.
but we did a lot of the programming ourselves, and we had good.
Did away with the coalition.
Unfinished project that works very,
I
very
think that
for what we
defense
do. So we maintain the
90%
server
was a
internally,
really,
we're 100% out.
really important
And,
document.
Yeah.
It seems to me, right?
Yeah, I think so. I developed something for us on Microsoft Access. One of the hash box.
Mm-hmm.
Power.
Well, the one where you're agreeing to not execute. major Boy Scout hearing going on right now. It's gonna.
Seems late in the day.
You know, very not, but after that. It happens right now that it's fine. So it's like, look at all this work I did. Oh, no. Oh, yeah. Yeah.
What time is the judge coming back? 3:06.
Or my pay grade,
Should be good now.
or technological abilities. Clerk, the deputy clerk kindly advises that it should be remedied right now. Thanks for letting me know. Please continue.
Thank you. So Mr. Balsita, then, since the fall of 2012, after you, at least in terms of litigation, stopped representing OELC, how frequently have you been retained by Philadelphia Indemnity to work on their behalf?
Since that time, I think that these, it's unclear in my head that when these cases were. They may have been a little before that, they may have been a little after that. But that would be the University of cases. I think the Bastyr case was after. I think the Gateways case, because there's two Gateways cases, both with the plaintiff with the initials MH. On one of those cases, I actually worked for Philadelphia. On another case, they actually retained separate counsel and we worked together. So my memory is right now that maybe the first case occurred before 2011, 2012, where I was actually assigned by Philadelphia Insurance Company to represent the insured. The second case may have occurred after 2012, and then I worked with David Russell at Keller Rohrbach, who was their assigned counsel, and I was assigned by another insurance company called Markel.
Was there a case called Mendez that you were retained by Philadelphia Indemnity to work on against Jack Conley and his firm?
No, there was a case, yes. And there were actually, I represented two defendants at two different times in that case, but it was actually Guide One Insurance Company that was the insurance company who assigned me in those cases.
Was there anything about the work that you did in the OELC litigation that resulted in any agreements or arrangements between either you or your firm and Philadelphia in terms of their contact with you?
Not that I'm aware of.
And has Philadelphia talked to anyone either at your law firm or any other interest associated with your law firm about whether they intend to pursue a malpractice claim against you and your firm as a result of the work in the Olympia Early Learning Center case?
Not to my knowledge.
Has there been any tolling agreements reached, anything like that you're aware of?
No.
Has the issue of your representation of the Olympia Early Learning Center been forwarded and notified to a malpractice carrier?
Not to my knowledge.
So how did it come to pass that you were retained by Philadelphia Indemnity to represent the Olympia Early Learning Center?
I was referred by David Russell, the attorney at Keller Rohrbach, who I believe does a lot of work for Philadelphia Insurance Company. I think he said that he told them that he was too busy to take on these cases. He knew that I had worked in this area before, and he referred me.
And by this area, what do you mean by that?
Sex abuse.
Tell us about that. And prior to the spring of 2011, how frequently were you the first chair lawyer in a child sexual abuse case that went to trial?
Once.
I'm gonna stop right there. It's probably really difficult for Ray to hear. Let's stop for a moment. Sorry, Ray. Are you okay?
Yeah.
Okay. Are you okay, Claire? That's okay. Have we got this figured out? Okay, we good to go?
Yeah.
Okay, back on the record. Sorry, Ray.
May I proceed, Your Honor?
Yes, please.
Thank you. So, Mr. Balsita, so prior to the spring of 2011, then, what I heard you say was that you had been first chair on one child sexual abuse case that had gone to trial. Is that right?
Yes. There was another case where actually the case was assigned to me, but I brought in another attorney, Ann Bremner, and at trial, she was first chair and I was second. Prior to trial, the roles were reversed.
And so is it accurate then to say that in the civil litigation history that you had in terms of the work that you've been doing, that there was only one case of child sexual abuse where you were the trial attorney?
That I was first chair at trial, correct.
So then I understand that David Russell from Keller Rohrbach was the one who may have reached out and made first contact with you about it or made the referral.
Who did you first make contact with at Philadelphia Indemnity?
I believe the claims adjuster, Jackie Holloman. That's my memory.
And that's Holeman is my memory, is that right?
That's correct.
And so what was the typical practice in your litigation work in terms of interacting with an adjuster at the beginning? Was it typical that you would make a phone call, that you would do a Zoom call? How did you typically go about it?
It definitely wasn't Zoom calls. I didn't do any of those before March of 2020. So it would be a combination of either email or telephone calls.
And what do you remember about how this transpired?
With Jackie Holloman, it was probably about 50-50 between emails and telephone calls.
Let me ask another kind of foundational question. Have you had an opportunity in the last, say, 2 weeks to review file materials so that you would be prepared to answer questions here in this hearing?
I did.
All right. And my memory is at the point in deposition, you hadn't reviewed documents when you were giving testimony then. Is that right?
No, that is not true. I actually reviewed the exhibits that both you and Mr. Rosner sent me to saying these are the exhibits that we may use at your deposition, and I had looked through some parts of the file as well.
And the reason why I asked right now is just to have an understanding in my own mind about how much I might need to put documents in front of you so that you remember. But it sounds like you've had an opportunity to review your materials.
I do, but you may need to put documents in front of me as well. It's been a long time since I actually was active on this file.
Understood. Appreciate it. So what have you had a chance to review recently?
I reviewed my deposition transcript, and I reviewed correspondence between me and Philadelphia. I reviewed correspondence between you and me. I reviewed some of the case files. For example, I reviewed the CPS investigation reports and law enforcement investigation reports. I reviewed some of the discovery answers that we received.
So you are, and let me make this official on the record, were you retained by Philadelphia Indemnity Insurance Company to represent Olympia Early Learning Center and the other defendants who were eventually added?
Yes.
Okay. And as such, what did you understand your responsibility to be to these various parties to that agreement, both Philadelphia Indemnity Insurance and then Olympia Early Learning Center and the other defendants?
I think my responsibilities were to the defendants to represent them zealously, and that I would interact with Philadelphia Insurance Company to apprise them of what's going on in the claim so they could make decisions about defense and indemnity.
And in terms of Philadelphia Indemnity and the contract that they had with you, what was their responsibility to you?
I don't know the answer to that question. I would assume their responsibility was to pay for my services that I rendered.
In terms of either, well, let me break this down. What was the typical practice with insurance companies that you worked with prior to May of 2011 in terms of giving you direction on a proposed litigation budget or a proposed litigation plan of action? What was the typical practice in terms of insurance companies giving you direction on what you might seek to do?
Well, with the insurance companies that I worked with, and there were not very many, because most of the work that I did was for risk management pools, and that's even more so true today. But I don't recall that there being a lot of direction with respect to that.
What was Philadelphia's expectation for you in terms of developing a litigation plan of action?
I do think they requested that I prepare a budget, and I do think that they asked me for a written assessment regarding the claims. But beyond that, I don't recall.
What do you remember in terms of their expectation for you checking in with them and advising them about the status?
I don't recall. I think that I don't recall what their expectation was.
And let me put it this way: do you think that was spelled out in the retainer agreement, or do you think that was more kind of a feel it as you go along?
I don't know if it was spelled out in the retainer agreement. That was not one of the things I reviewed. And so I could not tell you what the contents of that were today.
So do you have an awareness of when the exact point at which you were retained by Philadelphia Indemnity to represent Olympia Early Learning Center?
I think I received a letter from them May 27th of 2011. And that's one of the documents I did glance at before my testimony today.
And so what was the nature of that document?
I think it was an assignment letter.
Can you tell us what that is for those of us who haven't done insurance defense before?
That was a letter saying, we are assigning you to represent our insured in this particular matter.
And what did you know about the Olympia Early Learning Center situation at the point that you get this assignment letter in May of 2011?
Virtually nothing.
Had David Russell, for example, talked to you about it?
Only to the extent that this was a newly filed case and that he did not have time to take it on, and it was in the area of childhood sexual abuse. That's all I recall hearing from him.
And did the assignment letter provide any information about what had been happening or what had transpired allegedly?
I don't believe so.
And so that we're clear on the record, my understanding from your earlier testimony was that you think that you had been hired by Philadelphia Indemnity in prior actions prior to this point, May 27th of 2011. Is that right?
My memory is that they were one of the insurance companies who provided coverage on that first Gateways case. And I do think that actually precedes the Olympia Early Learning Center case.
And would your representation there have also been a product of David Russell from Keller Rohrbach, indicating he was too busy to work on it?
I don't know. It may have been, but I don't recall.
Do you remember what adjuster that you worked with on the Gateways case?
I don't. I'm sorry.
Did you have an understanding at the point that you get an assignment letter from Philadelphia Indemnity in May of 2011 that the adjuster that was working with you, Jackie Holloman, was 2 weeks into the job, roughly very new at Philadelphia Indemnity?
No, I was not aware of that. I mean, I don't think I was aware of that. I don't remember her saying that she was new to Philadelphia.
I'm going to ask, there's no foundation for the answer, and the question is testifying.
Actually, there is, because it's been stipulated that the exhibits are admissible, and we have Jackie Holman's exhibit, her deposition testimony is in evidence.
Well, I'm going to overrule the objection. The question is essentially, do you know if Ms. Holloman was new to Philadelphia Indemnity and in fact had worked there approximately 2 weeks? The witness says, I don't know. So the question stands, the answer stands.
Thank you. So tell us about what you did after you received the assignment letter.
Excuse me?
I'm saying initially.
Initially, I made appointments to go down to the Olympia Early Learning Center and start collecting information and start collecting documents regarding the claims.
And you made appointments, and did you follow through then and do exactly that?
Yes.
Okay. Tell us about what you learned.
Well, initially there were the claims for and are we using just the initials?
We are.
There were claims brought by SB and JS, and so that I believe was the initial focus. And
you can use Lisa Steele if that helps you, and Christy Barber.
Okay. So that was my initial focus, was finding out information about those claims. And actually, because there had been CPS investigations and law enforcement investigations on both those claims, the Olympia Learning Center had a lot of information on those. At some point shortly after that, I turned my attention to the SA claim and collecting information about that. And that involved doing more witness interviews, either by me or by the associate or by the paralegal who was working on the case, to get information on potential liability concerns there.
During these initial appointments where you went down to Olympia, it sounds like you met with personnel from the Olympia Early Learning Center, is that right?
Correct. As well, I remember also scheduling some meetings with their board as well to apprise them of what was going on and let them know about the litigation.
And my take was that you were gathering records during that process as you were down the line. Is that right?
Yes.
Were some of the records that you reviewed parts of the psychosexual examination which had been conducted on Eli Tabor by Sue Batson?
I don't think I got that document from the Olympia Early Learning Center. I did get that document, though, either through getting the law enforcement records or getting the CPS records.
At the point that you were doing the initial interviews and discussions with the Early Learning Center, had you become aware that there had been a fair bit of publicity about the arrest of Eli Tabor and some of the impacts on the Olympia Early Learning Center?
Yes.
Tell us about what you remember learning.
I do recall that after the abuse was reported and Eli was arrested, there was a period of great tumult at the Olympia Early Learning Center. I recall that there was a code of conduct that they wanted all the teachers to sign, and that it contained a non-compete agreement, and they lost a lot of staff and angered a lot of people over that. And this was all going on, in the months following the disclosure of the abuse, but before I had been hired. But the impacts of it were still continuing.
Do you remember Eli Tabor being arrested by Olympia police in roughly first week of February 2011?
I don't recall it. I was not paying attention to the matter when it occurred. I do recall hearing about that and seeing news coverage about it after I was retained.
And did you learn from Olympia Early Learning Center that they had reached out to Philadelphia to try to get some kind of relief or some legal assistance as there was this publicity about Eli Tabor, their employee? I don't
recall that. So if I knew it at the time, I've since forgotten it, but it doesn't ring any bells for me.
How soon after you started collecting records then did you receive the psychosexual evaluation for Eli Tabor?
It would probably have been within a couple months, because I think that we actually served subpoena ducis tecum on CPS and the city of Olympia to get their records within a couple months of my retainer.
Your Honor, with your permission, I'm going to get Exhibit 23.
Okay. With respect to time, we have a hard stop at 4:30 today. 4:30. If we don't go past 4:30, it doesn't happen. Yes.
Thank you. Mr. Policy that I think you'll find the psychosexual evaluation for Eli Tabor on Exhibit 23. Your Honor, with your permission, I'll publish that.
Yes.
I have it in front of me.
Well, so you had a chance fairly early on in your representation of Olympia Early Learning Center to read the psychosexual evaluation for Eli Tabor, right?
I did.
And without going line by line through it, have you had a chance to review that in the last couple of weeks, by the way?
Yes.
And give us your summary of what you remember from it and how it struck you at the time in terms of the task before you as the defense attorney for Olympia Early Learning Center.
Well, with respect to the SA claim, there was information in here that I thought was pretty damning with respect to damages, given his description of the abuse of SA. With respect to the others, I thought that there was it was helpful in the sense that Eli Tabor took a polygraph and had disclosed only two witnesses from OELC, two victims from OELC, and for example, JS and SB were not victims based on his polygraph results, which were deemed credible, and also that he said that he had never had sexual contact with any females, minors or adults, and that denial was deemed credible as well. there were things in here about that I would consider to be troubling sexual perversions, such as the admission of bestiality and the sort of the fetishism, things like that I thought would be troubling if they came to the attention of a jury. So in sum, it was somewhat of a mixed bag. There were some things that I thought were damaging to the defense of the litigation, and some things I thought were helpful.
At least in terms of the sheer enormity of the damages, particularly with respect to SA. If I have you take a look at page 2, and I've highlighted a few segments that I want you to take a look at. Did you understand the gravity of the injuries that this young boy, 4 years old, SA, had suffered as a result of the abuse by Eli Tabor?
Yes, I would agree that the description of the abuse was substantial.
And Your Honor, with your permission, might I go over the screen?
Yes.
So, Mr. Bolasina, I've got this top highlight part up here. You understand that Sue Batson in her psychosexual report is providing information that the Olympia police detective, Kevin Kolb, I think it is Kolb, had gathered from Eli Tabor. Did you notice that that was where the information, or at least some of the information, was coming from in the psychosexual evaluation?
Yes.
All right. And so you see this top part that we've got here on page 2, where Detective Kolb is asking SA how many times Eli touched his private part, and keeping in mind that SA is 4 years old at that time. Detective Kolb learns that it's a bunch, and Detective Kolb eventually clarifies that it occurred over 50 times. You saw that, right?
I did.
Pretty stunning number for a 4-year-old suffering child sexual abuse, right?
I've dealt with a lot of cases where there was, repeated contact over a period of time. So, but yeah, from a juror's perspective, that yes, it would be substantial abuse.
Well, remarkable, even if you in your career have seen equally horrendous or even more horrendous situations, right?
Yeah, it's a lot of occurrences.
Okay, and in terms of at least even what a 4-year-old boy was able to disclose to the detective in this situation where the boy's brought into the police station and the detective is asking the questions, I'm assuming that you noticed in the psychosexual report that this 4-year-old boy was able to describe oral sex that was being imposed on him by Tabor, anal sex that was being imposed on him by Tabor, right?
Yes, okay.
And were you troubled by the fact that the perpetrator, Eli Tabor, had been telling the boy, grooming the boy, warning the boy that they would get into trouble if it had ever been disclosed?
Well, yes, from a damages point of view, yes.
Right. And of course, what you're processing is the defense attorney is that you have a situation where the jury is going to be hearing that this perpetrator, who's the employee of the Olympia Early Learning Center, is telling this boy, eventually scaring this boy, and trying to prevent him from disclosing the abuse, right?
I think probably guilting him into not disclosing the abuse. I don't know about scaring him, but it's a manipulation.
Better said. Down on the bottom of the page, on page 2, you see the client's version of the offense. You understood that to mean Eli Tabor, who was the subject of the psychosexual evaluation, right?
Correct.
Okay. And you see Detective Kolb interviewing him on January 26, 2011. And I'm sure you are processing this as you're thinking about your defense theory. Eli, the OELC employee, is admitting the abuse, right, of SA.
Correct.
Okay. And he admits that he had sexual contact with him on numerous occasions since moving into the home, S.A.'s home. He said it started with masturbation, escalated to Eli sucking S.A.'s penis 10 to 30 times. So I'm sure you're processing that's oral copulation by the perpetrator of the boy 10 to 30 times, right?
Yes.
Not just mere fondling, but this is oral copulation by this some 17 to 20-year-old perpetrator of this 4-year-old boy, right?
Yes, I understood that's what it meant.
And you were processing also that it went on into this fetishism, as you described it, of Eli Tabor, the perpetrator, licking this boy's father, right?
Right.
And I'm assuming you understood that to be anus, right?
I did not understood what part of his buttocks he was being licked on. It just doesn't specify.
Let me read it for the record. Specifically, it says he also would lick his butt, right?
Correct.
He goes on to say Eli said on 2 occasions S.A. sucked on Eli's penis. And you understood that to mean that the perpetrator had manipulated the boy, the 4-year-old boy, into sucking this grown man's penis, right?
I did.
And you understood that, of course, would not play well in front of a jury in the event that got to a jury trial, right?
Yes.
And that would reflect on the damages that this boy, 4-year-old boy, had suffered, right?
Yes.
There's a last piece where it says, Eli said on one occasion he put his penis partway into his butt for about 10 seconds. You saw that?
I did.
You understood that to mean Eli, the grown man perpetrator, was anally raping the 4-year-old boy, right?
Correct.
And of course, that was also reflected in the boy's statement to the detective, where he describes that he asked Eli Tabor to stop doing it because it made him mad, and that Eli went ahead and did it anyway, right?
I didn't understand that the boy's testimony was that to Detective Cole.
So as you're thinking about your defense theory, you understood that this perpetrator, Eli Tabor, had forcibly anally raped the boy, right?
That's what was described, yes.
And that's not just what's described.
Well, actually, the boy could not consent under any circumstances. So, but this actually had an element of an additional element of lack of consent.
Right, because the 4-year-old boy was able to articulate that he told Eli to stop the one time Eli put his front private into S.A.'s butt one time. And he said he told Eli to stop because it made him nervous. Eli would not stop, and that made him mad, right? You understood that?
I did.
And you understood that would be described as a forcible anal rape of this 4-year-old boy, right?
Yes.
All of which was part of what you had to process as part of the understanding of the defense theory of the case, right?
Yes.
You mentioned that you felt relieved, I guess, in one respect of the psychosexual evaluation because you felt that it proved Eli Tabor was credible as to not abusing other kids. Is that right?
Right. He passed a polygraph that he had only 2 victims at OELC, and that was, the law enforcement considered that denial to be credible.
You mean Ron Young, the polygrapher, right?
Well, Ron Young, the polygrapher, but also law enforcement who actually relied on his polygraph to decide whether to pursue other charges against him.
Was there actually any other law enforcement reference that you could show us where they indicate that they believed Eli Tabor to the extent that he may have commented on any other child?
I would have to go through the law enforcement reports to see if there's that reference in there. But that was my sense, is that both CPS and law enforcement believed that he had disclosed his victims at OELC.
Do you know what the 3 questions were that were asked by the polygrapher of Eli Tabor?
They are identified somewhere. I've seen them. I can't.
Don't you recall them being incredibly generic in nature?
I mean, I don't recall him saying, did you molest this person? Did you molest JS? Did you molest SB? I don't think he was asked with that specificity, but I'm not a professional polygrapher, but this is what I've seen them do in the past when they do these exams.
Just so the record's clear, you agree that there was nothing in either the sexual assault evaluation or the polygraph examination where Eli Tabor was asked specifically about whether he had sexually abused the young girl JT, correct?
Who's JT?
Lisa Steele's son.
Oh, okay. I'm sorry. I knew her by different initials. No, he was not. I don't recall him being asked specifically about, for example, JT.
And let me just go through the record and make clear that you agree that there was no specific question asking Eli Tabor whether he had sexually abused the child Essar, right?
I don't recall that.
There was no polygraph question asking Eli Tabor point blank about whether he had sexually abused the boy JJ, correct?
I don't recall that.
Nor was there any specific question asking Eli Tabor under the polygraph whether he had sexually abused the boy AK, known as Junior.
Correct. I don't recall that.
And finally, there was no specific question where Eli Tabor was asked.
I'm sorry, I'm really worn out.
You need a break, Ray?
This is unrelenting. And I'm just wearing out.
Want to take a break?
I need a mini club.
Court's in recess for 10 minutes.
All rise.
Long day. Yeah.
As little as we've all done.
You guys all get to switch off and do other things. I'm doing
I'm sure these don't help.
Although, Mr. Kaufman is very easy to understand. We just that. I slow myself down. As is it works.
Oh, I feel I'm
You're doing all right.
okay. I feel like the mask is preventing me from enunciating as well as I could.
No, you're doing good. Just you're being so efficient that normally I get this little micro breaks, other pauses.
So we'll have to have a pretty long. For every reaction, there's an equal and opposite reaction. I know what. So there, this is the result.
Interpreters, they get to work in pairs, or sometimes three peeps.
Mm-hmm.
Each other.
I had an interpreter for a case. I don't know. It was a couple years ago, and she basically chewed us all out because we had only hired one for a day-long deposition, and frankly, it does, like court reporting, it looks exhausting.
We're doing the same thing.
Yeah, it looks exhausting to be. Mm-hmm.
Thing with the sign language people.
I just like to put on the record a sigh.
I think I told you so.
Well, that was my first reaction. I decided to keep that off the record. We should just go back to the hotel.
Different fires this
No, we were too optimistic. Based on bad information.
Didn't notice.
We get to use the parking we prepaid for.
Not many.
Yeah.
Not really.
I suppose if they didn't, they'd just tack it on to the green fees. Maybe it's nice for people that didn't pay cars. Never seen something like that. Valet I've been charged for, but I don't think I've been charged just to.
So once in Portland, I decided to be cheap and park in a different lot than pay for the valet at the hotel. My car got broken into, back window broken out. They stole my laptop.
Oh my gosh. What are you doing leaving your laptop in your car?
It was in a backpack. And I had gone out after we had done something that we were going to do something with a client. And we had gone like to go do a zoo booth in Portland. The animals at night for deer. And I just had forgotten that we had the backpack with the laptop.
I'm gonna say that my backpack's in the car right now, in that lot. Oh,
After that, I bought the cover that hides what's in the back.
well, it's.
I did not
under
have
cover,
that
yeah.
I also didn't know it was the day of the Rose Festival parade or whatever they had in there. Apparently that was a bad. A lot of people got hit that night. And I also found a guy in my car at the lot at our office in Seattle.
Creepy.
About 6 years ago. I broke into a window. I was still in the car when I got out there. And I tried to take a picture of him, but my camera was turned around, so there's a picture of me. And then he's like, I said, stop, you need to stop. The police want to talk to you. And
He was running out.
yeah, and
At least he didn't stay in there.
he said he had a gun. And then I was like, go ahead, go. Take my Seahawks hat. That's what he stole, a freaking Seahawks cap. Some, there wasn't anything in my car. And when I called the police, they were asking me for a description. I'm like, okay, he's wearing, what, blah, 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 and Seahawks. It's my Seahawks hat.
There's around here, there's a lot of Seahawks hats.
Anyway.
I have a cousin who had this happen where somebody broke in your car in a car fix-it lot. And he was sitting in the car and he wouldn't get out. And they couldn't get him out. And because they had to call the police. And the police said, if he's claiming it's his home, we can't evict him. So it was terrible. They had to call
That seems
like a
bonkers.
social worker to come down and they offered him and gave him a $50 gift card to Safeway, and that got him out. Can you believe it?
So there was just an incident in Woodinville, where I live. Some guy went to berserk and just trashing his girlfriend's apartment and ran into somebody, hit and run, and ran away. And then he was out back at the apartment building, breaking up the front door, and the police let him. They just decided to let him, like, wear himself out. And then they arrested him. And I went, oh, maybe that was the right thing to do, you know? It's property damage as opposed to
Human right.
Yeah, but
Rather a broken door than a broken person, so.
yeah, but as long as he didn't run away and crash into anybody else.
Was there anybody in that apartment though? 'Cause if they weren't.
It was the front. They had pictures of it on the news. It was like the glass in the front of the building smashed up.
Because if the girlfriend is sitting there inside, hearing him close the door, that would not have been.
She called when he was busting up the place. Then he drove away, had a crash, and then he came back. And the story kept talking about the fact that he was 7 feet tall. I guess it was pretty hard to miss.
No, there aren't too many guys outside the NBA walking around over 7 feet.
Yeah, that is pretty tall. My father-in-law was 6'9". And if you're 6'9", you cannot fit in the rides at Disneyland. We learned.
I dated a guy in college whose father was 6'10", and my then boyfriend was 6'8", and his dad came to visit, and just, hello, gentlemen. His mom was almost 6 feet tall. They're all
My wife is 5'11", a little bit more. And her sister was 6'2".
very tall.
And my family is all very short. My father was 5'6". My mother was 5'2".
Oh my goodness.
I have 2 sisters who are 4'11".
No.
Honest to goodness. And
How'd you
an
get so
aunt
tall?
who was 4'8". And my sister's husbands, 2 of my sisters, they're both kind of short. So I was tall Paul.
That's a nice thing.
At least with that family. My wife's family, I was just kind of normal.
Sure, Paul. Yeah, normal Paul. Families of giants roaming around.
What's that?
I said, families of giants roaming around.
Well, I got my kids have a little bit of the college. I have a nephew he's about 35. He's 5'3".
That's pretty short.
He doesn't seem to have any issues with me.
No, sure, complex.
Yeah. He's a video game tester in Las Vegas.
Oh, double fun. Does he test the gambling games also?
All right.
Please be seated. Thank you. Mr. Cochran, you may continue.
Thank you, Well, I want to finish off the line of child plaintiffs in the Olympia early learning litigation in terms of whether there were specific questions in the polygraph exam. And let me ask you about M&M, the boy M&M. Do you agree that there were no specific questions asked in the polygraph exam about whether Eli Tabor had sexually abused the boy M&M?
I agree.
And you remember the questions instead being limited to 3 questions. The first one being, other than you told me, have you ever had sexual contact with any other minor child? Being one of the questions.
There's a few word changes, but essentially, yes, that is what he was asked.
You remember the second question being this, other than you told me, have you ever had sexual contact with anyone else after they told you no or tried to push you away?
Yes, correct.
And the third one being, other than you told me, have you ever had sexual contact with any other family member?
Correct.
And so you understood those to be very, very general, generic type polygraph questions, right?
Yes, consistent with what my understanding of how polygraph exams are done.
Some of them, right? Because you can have specific questions designed to determine whether a alleged perpetrator has sexually abused a particular child. That just didn't happen here, right?
I don't know enough about polygraphs to tell you whether
Argumentative.
that is, I'm sorry.
That's okay. That's okay. There's an objection. The
Argumentative.
objection is that it's argumentative. The objection is overruled, and you may answer the question.
I'm not an expert on polygraph exams. The ones that I have seen seem to ask general questions like this in order to gauge the issue of whether there are other victims.
Did the psychosexual evaluation by Sue Batson indicate concerns actually with Eli Tabor's credibility?
There may have been some. I don't recall.
Let me turn your attention over to page 7. There's a section that you'll find there that's called the summary and conclusion section. And you'll see particular paragraphs that says, there are several other factors which cause this evaluator concern. Let me know when you found that paragraph.
Where is it on the page? Oh, is it up there?
5/7 of the way down.
And you said this on page 7?
Oh, gosh, yeah. You can't see it very well in this projection on the screen, but page 7, exhibit 23.
Got it. Okay.
Paragraph starts, there are several other factors which cause this evaluator concern. It says, perhaps most concerning is related to the fact that he has a sexual attraction to children and was working in a target-rich environment. That paragraph goes on, though, and says, and I'll quote it, he claims he reported this to Detective Cole, who informed him he was not concerned with that information at that point in the investigation, given the concerns that he could have assaulted multiple victims at the child care center. It is hard to imagine Detective Cole would have dismissed such a statement. Do you see that?
I do.
And did you, first of all, process that what Ms. Batson was talking about was that Eli Tabor may have failed to disclose to Detective Cole that he had sexually assaulted another boy at the Olympia Early Learning Center?
Yeah, I'm not sure what, with the passage of time, I'm not sure what she's referring to here.
Let me read the sentence. Quote, he admits prior to meeting S.A., he was sexual with another 5-year-old male at the child care center when he was 17. He claims he reported this to Detective Cole, who informed him he was not concerned with that information at that point in the investigation. And Ms. Batson goes on and says, given the concerns that he could have assaulted multiple victims at the child care center, it is hard to imagine Detective Cole would have dismissed such a statement. Does it make sense now?
Yes, I don't recall basically the relevance of this to the investigation they were doing.
How about the fact that the credibility of Eli Tabor was not something that would stand as one of the bulwarks of your defense theory?
Is that a question?
Yes.
Is that a question?
Yes.
Well, actually, I mean, given the other facts associated with the other 5 victims, I do think it would actually, that the fact that he admitted to SA, he admitted to Nolan Dolly, even though no one actually knew about Nolan Dolly being a victim at that point, and the other facts and circumstances for the other 5 plaintiffs, I do think his credibility would be an issue that I would put before the jury.
Presumably then that you were willing to accept all of the other paraphilias and sexual deviance of an extremely deviant nature in order to get to this credibility assessment with Eli Tabor? Is that what you're saying?
Your Honor, I'm sorry, I didn't understand the question.
I don't either, but I think, let's see if the witness does.
I don't know. I kind of lost it.
Happy to rephrase.
It's an argumentative question, Mr. Cochran, so I'll sustain it on that basis, but you can rephrase the question if you'd like.
Thank you, Your Honor. If your defense theory, or at least one aspect of it, was that you were going to attempt to convince the jury that Eli Tabor was a credible source when he said that he had anally and orally raped S.A. and sexually abused another boy, but believe him when he says he didn't rape anyone else. You understood, presumably, that you would have to endure the fact that his fetishisms and his sexual deviance would come into play in the trial, right?
If they weren't excluded as being overly prejudicial under 403.
Understood. But I think that you've indicated under oath before that you were wanting to go to the jury with the polygraph exam as part of this defense theory of yours, that the jury would believe Tabor when he said, well, I sexually assaulted these two boys, but didn't sexually assault others.
Well, it's not, there's more to the story here than just him denying the other victims. There's also, with the two girls, the fact that those were investigated by CPS and by law enforcement immediately after the disclosures were made, and no one had credible evidence that Eli Tabor was anywhere near those girls when they claimed to have, after they made statements that they were molested. And so there's other factors as well. I'm not just going to say if a child appropriately discloses abuse and Eli Tabor says, I didn't abuse that child, then I would say his credibility is not something that I would ever rely upon. But when there's other facts and circumstances that actually corroborate his credibility or don't support the allegations of abuse, then it is a factor. And that's why I think it was a factor with respect to these other 5 claimants.
Mr. Bolsini, you slipped into a narrative where you were just going to justify your answer, but I'd ask you just to kind of stay focused on my question, because I'm happily going to get to the opportunities Eli Tabor had with each of the girls and the others momentarily, but we haven't gotten there yet. So back to my original question, and actually I'll slightly change our focus on this because I want you to look a little higher on page 7, up above in the paragraph, up above the summary and conclusion sections. In fact, it's the paragraph that says Eli completed a myelin clinical multi-axial inventory 3. You see that paragraph?
I see it.
About 8 lines down, it says this sentence: his scores were highly elevated in the categories of avoidant, dependent, sadistic, negativistic, and anxiety. You see that?
I do.
And did you process that in terms of your defense theory?
No, I don't think I considered that at all.
So then you were overlooking the fact that one of the traits of this sexual deviant was a concerning sadistic nature that was being revealed by the psychological testing. Is that right?
I did not consider the results of the myelin clinical multi-axial inventory 3 at all. I don't remember giving any thought to this.
So this exam, by the way, was administered with Eli Tabor, at least as we see in the front page of Exhibit 23, on April 4, 2011, and included in an official report on April 25 of 2011. You see that?
I do.
And do you remember the first complaint, the Lisa Steele complaint, coming in and being filed on April 29 of 2011?
I don't. I know it was before I was retained, but I don't recall the date.
I'm going to turn over to Exhibit 41. With designer's permission, I'll publish 41.
Yes.
Do you see it?
One of our charges in this reasonableness hearing is to evaluate the plaintiff's theory of liability. You understand that, right?
Yes.
The complaint that you eventually received for the Steele case, after you were assigned the case by Philadelphia Indemnity, was a complaint in form that looked very similar to other sexual abuse complaints that you received over the years, right?
Probably. I mean, it would require me to compare this, and I'm not sure on which way you're asking me to compare it.
Is it substantially similar to kind of the form and nature of complaints in the child sexual abuse case?
Yes.
And specifically, if we go over to page 3 and look at it, you'll see plaintiff's theories of the case, the negligence theory in the case, right?
Yes.
Which you understood under Washington law, all the way dating back to the McLeod versus Grant County case in 1953, the type of negligence assertion that was made in this case, right? A
Yes.
failure to protect the child.
It's the same claim that was made in all of the lawsuits that I was involved in the defense of.
Basic theory, and Your Honor, I'll approach the screen again with your permission.
Yes.
There is a allegation in the negligence complaint that there was a responsibility for care and supervision of the child, and that was failed. That there was also a second duty to control the employees, that being Eli Tabor, and that was breached as well, right?
Yes, that's how you pled it.
And it wasn't just negligent hiring, it wasn't just negligent retention, it was monitoring of the male staff, it was the failure to put in place policies to prevent a male staff member who might be a danger and giving them access to the child, right?
That is an unusual theory, and not one that I've seen before. That an agency like OELC should have different policies or different practices depending on the sex of its employees. So that's an unusual part of this claim that I haven't seen, and I would be concerned if an agency did have separate policies with respect to its male and its female staff.
Whether it's a male staff or a female staff or undesignated as to the gender, did you understand that the allegation was that OELC shouldn't have been leaving a single person in with access to the child?
Yeah, that was the standard of care at the time was not to have single employees have unsupervised access to minors for purposes of the minors and the adults protection.
And by the way, you learned in the course of the interviews that you did with employees at the Olympia Early Learning Center that was routinely violated at the Olympia Early Learning Center, and in particular by Eli Tabor, right?
I do recall that there were conduct issues with Eli Tabor following policies, including that one.
Which would bolster the plaintiff's theory of liability in the case, right?
And which case?
SA, for example.
Yeah, definitely with SA.
But I mean, at least in terms of liability and establishing negligence, regardless of which child it was, the plaintiffs were going to be able to establish through employees in the Olympia Early Learning Center that Eli Tabor was known to be violating the policy which prohibited a single staff member from accessing child by him or herself, right?
Yeah, I believe so, that there would be evidence of that.
I'm still here at Exhibit 41, the complaint. I also wanted to point out here on page 4 that there was a separate loss of consortium claim, and that being the claim for injury to the parent-child relationship with the parents, right?
Correct.
And my memory is that at one point that you indicated to Philadelphia Indemnity that the parent claims, the strength of the parent claims were a problem for OELC and for Philadelphia, right?
The strength of some of the parent claims were. I believe that I said that, for example, for those people who I believed were truly victims, that the parents would have legitimate loss of consortium claims. So for SA's mother and for ND's mother, if he were to sue, I was concerned. My focus with the other claimants was whether there was credible evidence that they were abused at all, based on what I knew in 2011, 2012.
We're going to look at it specifically tomorrow, but do you remember actually indicating to Philadelphia Indemnity's adjuster, Jackie Coleman, that there was a concern that all of the parent claims were strong because each of them had a valid concern that Eli Tabor had molested their child?
I don't recall that. I don't recall saying that, and I don't recall thinking that. So if you've got something to refresh my memory, I'd be happy, but I don't. That doesn't ring any bells in my mind.
I'll make sure that I show you that tomorrow. So this is April of 2011 when this complaint comes in. You've indicated that you were assigned May 27th of 2011. I want to turn your attention to Exhibit 64, and I think I'm going to have to get a different book for you. Published 64 for the commission.
Yes.
Bossy, I'll make sure that I give you a chance to go ahead and read that.